sprang from three clear legal errors. And if I could take about 90 seconds to give an overview of what those errors were and why they denied the hospital a fair trial, I'd say first, the plaintiffs were allowed to accuse the hospital of causing the suicide
I got to boost the volume. This is terrible.
3 months after the mother had last set foot in the hospital. Second, the plaintiffs were also allowed, without any competent evidence to prove any of the elements of insurance fraud, to repeatedly accuse the hospital of engaging in fraud, lying and stealing from the family that sought care at the hospital. And third, the trial court profoundly misconstrued the protections of Chapter 39 immunity, limiting it only to reported immunity.
Got gel on my hands.
At the
literally doing my hair.
These
I can't get my earphones in.
Errors set the stage for wild.
How do you have no sound?
This is a hospital that kidnapped and tortured a little girl.
No sound.
To kill her mother. That did not give the hospital a fair trial, and a retrial is necessary that does not include claims that we caused the suicide of a non-patient, that does not include unsupported claims that we engage in insurance fraud and steal from our families, and only follows a proper application of Chapter 39 such that the hospital is not held liable for conduct that is protected by the order of the legislature, and even for conduct that wasn't even hospital employees or agents, that was state actors.
Could you round out your understanding or your position as far as the immunity? Obviously, you feel it's too narrowly, the statute's too narrowly construed. How would you view the immunity that the hospital arguably is entitled to?
The immunity first expressly covers any act authorized by Chapter 39. I think that's the first important point because the judge said it covers reporting. From there, the authorizations, Chapter 39 is a voluminous chapter, and the legislature has said that this is a robust immunity. Courts have said this is a broad immunity, and there are very strong public policy reasons for that. I think particularly relevant here, there are immunities granted under Section 39.303(3) subsections A and subsections F that apply to the Child Protection Team. Dr. Sally Smith, in this case, is the Child Protection Team Medical Director for Pinellas County. She was actively involved in what were child protection activities throughout. Subsection A in 39.303(3) gives her the power to diagnose and evaluate a patient. It gives her the power to order laboratory tests, to perform x-rays. And subsection F gives her the authority to collaborate with the treaters to develop a treatment plan.
You would agree that even with the immunity, that if there were an intervening tortious act by the hospital, that would not be covered under that immunity?
It would depend on what the act is. The problem here is that much of the immune conduct was just labeled tortious. You tortiously.
Well, let's just take the claims as they are, the intentional infliction of emotional distress. If that did indeed play out, then would that be covered under the immunity as you've just described?
I think a true case of intentional infliction of emotional distress would not. And I think what your question's getting at is this an absolute immunity? If a child is being protected, anything goes, and that is not the position of the hospital. It is certainly possible that intentional torts can be inflicted upon someone and there would be accountability. I think a good example on the medical malpractice side was that if a patient had appendicitis and Dr. Sally Smith performed an appendectomy because she's skilled as a surgeon, and this is hypothetical, of course, but if she performed an appendectomy and botched it, you could bring a medical malpractice case saying, well, that's not child protection activity. But what the hospital was held to account for here was Dr. Sally Smith is going around and asking questions, and she's rude and she's weird and she's got this raspy cigarette voice, and I'm trying to clean up my child and she's asking me all these questions that don't really seem related to what we're there for. That's core investigative child protection activity.
Well, let's go. Can we go to the intentional infliction of emotional distress claim by the estate?
Yes.
Okay. There's the case of Nelson, which I'm sure you're familiar with, because you're relying on it for the intervening cause of the suicide, that would absolve any liability by the hospital. And so in looking at Nelson, it allowed a claim of suicide to go to a jury, right? Because it remanded for trial. And so it talked about the difference between one being driven to suicide versus the actions and circumstances, and I'm paraphrasing, but driving one to be mentally ill and then that person on their own volition committing suicide. And I focus on that because that distinction is the issue. I believe the court in that case is why they took it and it became a jury question. Why do we not have that same jury question here, where the
Exactly.
facts are that we have?
It is a jury question, and they answered it.
Was that Mrs. Kowalski was, we had the Munchausen, I think I'm pronouncing that correctly, by proxy. And so they've already indicated that there's a mental illness there. I believe one of the doctors had mentioned, his name is escaping me now, but I believe one of the doctors had mentioned that she was in some sort of mental state, as maybe had relayed some information to them to that effect early on upon admittance. And then you have, after that, you have, and I realize while they're not direct, some of this isn't direct to her, but you have statements by Nurse Beatty to the husband saying, why don't you divorce her?
Mm-hmm.
You have
Preach.
statements that the daughter's faking it.
Yep.
You have
This case was outrageous.
you have some allegations of interference with her religion, and it was noted that she was extremely religious. And you have them challenging her medical profession.
They threw Jesus in the dumpster. Let's not forget.
For the way that she treated her daughter. So my point to all of that is that's like everything of the woman. That's like her whole existence. It wasn't just one thing that she was being challenged on. It was all of those things. Why is that not enough evidence on the issue that was the Nelson that they remanded for, not enough to go to the jury?
I think the most important distinction is that Nelson versus Seaboard is a FELA case, the Federal Employers Liability Act, and that has a almost non-existent causation requirement. FELA cases, the instructions to go to the juries are, if you find even in the slightest that this caused, you can find liability. It is significant that this is a 1980 FELA case, and we don't have a case in the following 45 years where a Florida jury has been asked to find someone liable for causing the suicide of someone who there's no clear duty owed to. And I think that the other part of your question I'd like to address is, how do we not feel for a mother who's accused of abusing her own child? And that ingredient is present in every single child protective action that the state and pediatricians and social workers ever take to separate a child from a parent. It is always traumatic. It is always awful. It is always terrible.
Well, on that point, following up on Judge Smith, if the hospital's operating under a shelter board, to what extent and what is the nature of any duties or obligations they might owe to the parents?
There are profoundly different obligations. I think one of the core principles of child protection law in Chapter 39, and we see this in the case law, The duty is to the child. This law exists
Yeah,
for
they
the
have
benefit
no-
of the child and not for
No
the
duty
parent.
to the parents at
Because
all.
the parent is always outraged, is always upset, whether the allegations are true.
So
whether
they
the
trample your
allegations are false,
constitutional
they're
rights,
going to be devastated, furious, and they
and
are
they
going
drive you to
sue.
suicide.
And because of that, we have a history of healthcare providers who are very chastened, very nervous to get involved, because the entire history of child protection legislation since 1963 in Florida has been, you need to get involved, and when you do, you will be protected from litigation.
But don't you have to balance that with a parent's, we're talking about minors, don't you have to balance that with the parents' rights that they have with the hospital? I mean, they're the parents of the minor child who's a patient in the hospital. and
They have
can't
14th Amendment
coexist.
rights.
They can coexist, but the legislature has made a clear policy choice, because in all of these cases, there is this fear, what if I'm wrong? Or what if I'm right, but there just isn't the proof? How much blowback is there going to be? And the history of these cases across the country is there is very often fierce and intense blowback. People are angry about this. And if this
They
is
should
allowed
be.
to go to a jury will be angry about this.
And we should
And
be.
the testimony at trial amounted to, if you're going to accuse someone of child abuse, you had better be right. And the entire history of child welfare law is that is fundamentally wrong. It is the exact opposite. It is that if you have merely a reasonable suspicion, you have to report, you have to get involved. And doctors now face risk of losing their licenses. They face criminal liability.
Let me ask you this. Was there anything in the,
She's not interested.
5 dependency orders, was there anything in that limited the parents' rights to be informed of Maya's treatment or participate in those decisions?
The parents were included, that they would have decision-making authority. It is necessarily a massive limitation of their rights as parents when the child has been removed from the state and is being sheltered in another entity. And when the reason for this is the good faith belief, and I want to emphasize, good faith is an important limitation. You are not protected for bad faith actions. You're mad at your ex, you're mad at your neighbor, and you accuse them of child abuse to mess with him. That is not protected at all. This is good faith child protection activities, and there is an inevitable
ignored the experts.
conflict. These are always
Didn't even interview the
awful,
doctor
terrible,
that
raw,
Maya
sensitive.
had.
Didn't remove the parents' rights to be informed and to be involved.
That's right. The juvenile court never
Certainly
did
not
that.
as an absolute matter, but there is, for instance, when they want to do video monitoring, they want to have the child in a room for 2 days to monitor without her knowledge, just to see, because they're repeated from the immediate outset, vast discrepancies between what they're reporting she can and cannot do and what they're observing with their own eyes.
And that was something that I believe the testimony was approved through risk management.
Yes, an assistant risk manager approved of that.
And
What's the difference? What does a hospital use as a guide to interacting with the parents to get consent, or at least inform them? And in the case of the monitoring, just doing it on their own, the advice of the people who were involved might be risk.
A lot of these Chapter 39 orders give this discretion to the hospital. They say the hospital has these rights, these rules are in place, the parents have these rights, but all these things like visitation, care, this is going to be done as seen appropriate by the hospital and consistent with the best interest of the child and the best interest of the care. When the theory of the case, the theory of the detention is the mother may kill this child. The mother not only, and this is not a case of a parent who drinks a case of beer and starts wailing on the
She
kids,
was not going to kill the child.
Separation solves it. This is a psychiatric dynamic that's going on between the two, and that's the leading theory. And the mother is not the patient of the hospital. And if it's presented as a medical malpractice case where, well, did you have advanced psychiatric experts? Are you absolutely certain the mother had this problem? that cannot be the standard. The hospital has to have,
I'm trying to get my arms around this, how is it in the best interest of the child to videotape her?
Yeah.
through
Yeah.
her theory, when the risk was that if she was incapable of getting out of bed, they would rather her
Fall.
to prove that
Yeah.
the mom was right,
Oh my God, I love this judge.
to prove that she actually was a victim of abuse, housing by property.
Oh.
no, there's no desire to create a fall or anything like that. And that among all the
That was the
conspiracy
risk
theories,
that
that
they
is not been
took.
suggested that they wanted the child to fall.
That is
The
the
idea
risk they
was
took.
there is necessary for medical and for child abuse investigatory reasons to find out why is there this very strange, immediately apparent discrepancy between what they say the child can do and what she does right in front of their own eyes. There is a vast difference in her behavior from when the mother is in the room, from when the mother leaves the room. They are presented with a bizarre situation. This girl shows up and the mother reports she has been put in a ketamine coma that we took her to Mexico to do because they're not
Stop
done in the
scaring
United
people.
States.
Stop it.
And we've been taking her to
Just
a
stop it.
doctor who advertises on the internet as nopainhannah.com, and he's pumped her with 55 ketamine infusions at levels that are 10 to 100 times the amounts that this hospital would ever give a child.
Was that was under the direction of the medical doctor here in the States, the referral was, right?
The referral to Mexico, or
No, I think the referral to the doctor, was that under the advice of the medical doctor?
Yes.
That she was being treated by?
you can find doctors in Florida that will sell you pain medications, and they got
That's not what was
$10,000
happening.
ketamine 4-day treatment from Dr. Kirkpatrick. Dr. Hannah sold them ketamine at least $1,000 a pop 55 times. The Mexico ketamine coma was $40,000 plus. There are doctors who will sell you high-powered pain medicines and prey upon vulnerable families who are desperate for some solution. And everyone loves an easy solution. Ketamine's a magic drug. This will fix your daughter's problems. And the healthcare providers, when they are presented with this, they call Dr. Hannah. They ask, we're getting these reports, what's going on? They ultimately agree to titrate her down, but to give her these high levels of ketamine that were the same levels that put her into a coma just a year before. But her tolerance has grown so high that as her mother writes in a blog, writing in the first person as Maya, I'm taking enough drugs that would kill a horse. I mean, that's not hyperbole. She's taking massive amounts of ketamine because she's built this high tolerance, and the care providers are gobsmacked by this. They do the due diligence, they file a report. It is found as a matter of law. They had good faith reasons to file this report. It is immune conduct, but yet the entire and they also won summary judgment on civil conspiracy. They won summary judgment on malicious prosecution, and they won summary judgment on intentional interference with the parent-child relationship. Those were all proper, and none of those are being challenged on appeal. They won those, and what they had to do was defend a medical malpractice case that made all of those same claims. You're interfering with the parent-child relationship. This is malicious prosecution. You just don't like this mother because she challenged your opinions, and you're out to destroy her. And what that,
your end game?
I think the end game is that
you want a new trial? If we agree with you, a new trial or strike through various damage items?
we certainly need to strike through the suicide claim. That is not appropriate. There is nothing remotely close to the level of extreme and outrageous conduct beyond all possible bounds of decency, conduct utterly intolerable in a civilized
That's exactly what they did.
This is child
Utterly
protection
intolerable.
activity by licensed pediatricians, healthcare workers
Disagree.
who admittedly have an honest disagreement with the family over what's the proper medical care. The actions of Sally Smith are entirely immune. Those are Child Protection Team medical director expressly authorized actions. The hospital cannot be tied to her and have to defend Sally Smith's conduct.
She didn't identify herself.
The retrial, to answer your question more directly, cannot include claims of insurance fraud. This was put in purely for the poisonous effect it had on
I
the
think they did
jurors
commit
and the effect it
insurance
had on
fraud.
their view of the hospital. This is a hospital
They
that
billed
lies, cheats,
for
and
CR,
steals
yes,
from its patients. It's rotten
while
to the
denying
core.
that she had
And
it.
when it got to closing arguments, the plaintiff said, you know what? Just give us $1 because we don't have the evidence of this. They're thrilled they were able to say it for 8 weeks, but we don't have the
Really
evidence.
need to
Just
dry
give us
my hair.
$1. The jury gives them $5 million, even after the plaintiff's request, just make it $1. And in the briefing, you see that the plaintiffs still argue that the IIED claim is supported by the evidence because of the evidence of fraud. You know, this jury could have found it because of the fraud. This was you don't bring a $1 claim unless it's going to deliver something. And this delivered immense prejudice against the hospital. So that's the second part of what a new trial can include. I think the third part is that the new trial must follow proper application of Chapter 39, which will sharply limit the type of evidence that can come in at the retrial. So much of what was presented at the first trial was immune Chapter 39 conduct, even conduct by child protection team workers going in and confiscating this food, taking away the sacrament. I mean, things that are very sensitive, taking away her laptop, taking away her cell phone. These were actions done by state actors, or whether they're contracted through Suncoast,
It was not necessary.
non-hospital actors as part of their child protection duties. And they are
And we're the ones you just laid out here, were those specifically laid out and authorized by the dependency court orders for them to do?
Mm-mm.
I don't know that
Nope.
the court says iPad,
Nope.
but the actor, it is the child protection team.
Court
is
never
making
said
these
that.
You're
decisions.
saying simply because they are a child.
We read the
protection
juvenile
actor,
records.
whatever they do and they think is right is immune.
I'm saying that A, they're certainly not the hospital. B, there's the immunity should be broadly construed as a robust immunity. And I think there's a very strong presumption that when
What does that mean exactly when you say robust? Is there a case authority that talks about that, or what does that term mean to you?
I think it means that
You've got a microphone, man. Use it.
A policy.
I know. Put it in your mouth. Why is it so far away?
Specific good faith requirements in 39.
Yes.
But I don't know that that's defined anywhere.
Yeah, I mean, and the word robust actually, I think, comes from the trial judge himself when describing the Chapter 39 immunity before failing to apply it. I think it goes to the idea that these situations are always terribly sad. And if angry parents can
It's
bring
terribly
lawsuits
sad that Jay Hatch is
that
in
quibble
jail.
over details, you were allowed to do this, but it didn't expressly say you could take
Never
the
mind.
iPad. So I'm going to say you maliciously took my iPad in order to make me miserable. And I'm going to talk about how sad I was for 97 days. And I'm going to have experts refer to my hospitalization and sheltering as a captivity.
Just remember.
I'm going to use this language of kidnapping, abduction, and
Yep, that's what they did.
torture.
Was there an option?
Kitty stealers.
Where she could receive care when the trial court was considering the shelter?
It was a fluid situation. There was the initial detention, which was done by the hospital, and that's under 39-395.
And that's their initial report. That deals with their initial report.
There are even 2 initial reports. There's an October 7th report and October 9th report. The October 7th report, the reporter says the parents are cooperating. They're doing what we want to do. And DCF's response is, well, then we're okay. Then if they're doing what you suggest, we'll leave it alone. A few days later, they call back and they say, we have much graver concerns now because of what we've learned in the last 48 hours, and an investigation is opened. That point creates enormous protection and immunity for all of the good faith child protection activities. Again, if you're operating in bad faith, that's an entirely different matter and you're not protected. But good faith child protection activities must be broadly protected, because if someone is on
Look at this
a
fossil.
91-day sheltering 24 hours a day for months on end, who is able to get, just through testimony, someone said this, I didn't like the look on her face when I was talking to my mother. I mean, they go to trial over facial expressions. I didn't like Kathy Beatty made bad faces when I was talking to my mother. And when they're saying She also constantly interrupted when my mother and I would stop speaking English and began speaking in Polish. Well, that's in the order. You know, you've limited, they're worried about the psychiatric dynamic and the pressure being put on the child by the mother. And a clear stipulation is, or not stipulation, a clear part of the order is, you know, these are going to be monitored calls. And of course, they have to be in English. If you switch to a language that the monitor doesn't know, you're no longer monitored.
Can you clear up something for me related to the false imprisonment? At what point in time between the first?
They're not plugged into the court audio. That's the problem.
In October 7th and the next one, when did the Kowalskis ask to leave the hospital?
It's not entirely clear.
It's not to me either.
Yes, and I've spent a lot of time on this, and I can't delineate exactly when and where. There is the testimony, we were threatened, we'd be arrested, and the light most favorable, we have to go with the assumption that they did detain the child. I can't identify what day, what time that happened. But there's also, throughout the medical records, repeated references to extensive communication, family meetings, and consent. They agreed to placing the nasogastric tube. They agreed to a colonoscopy.
And they later agreed to stay in the hospital.
Yes.
At some point in time. I guess my next question to follow up on this is, were they forced to stay? Because there's some allegations here that they would only leave if the hospital would remove the Munchausen by proxy with syndrome from the records.
So let me interrupt that. We do want you to answer the question, but you're in your rebuttal time.
All right.
But please answer the question, or else I get yelled at.
I'm sorry. Could you please?
What was that, is that an accurate depiction of what happened, that they were not allowed to leave unless they agreed to the theory of the hospital that she was a victim of Munchausen by proxy?
Thank you for repeating it. That's absolutely false. That is what they present as their interpretation. The medical record is prepared. The hospital wants to transfer them to Nemours. The family wants to go to Nemours. But the mother's intent, I want a clonidine pump that is inserted into her spine that provides these massive painkillers. And Dr. Santana Rojas at Nemours says, well, we're not going to do that. Dr. Rojas is a CRPS expert. And the Hopkins throughout admittedly said, we are not CRPS experts. But we are, professional child anesthesiologists, pain management experts, pediatricians. This is one of the elite hospitals of Florida. There's a lot we can do, but we're not the ideal place for this case, which has a psychiatric dynamic and a CRPS dynamic, and we want to move you there. The parents spike the plan. They do have to consent to the move. The hospital's ready, Nemours is ready, and they say, take out this part about suspected Munchausen. And the hospital says, well, no, that's the medical record. That's the honest view of the hospital. And they argue at trial, this meant we would have had to agree to it. It doesn't mean that. You can write, that's what you think. I disagree. And that's just what's thrown to the jury is we were trapped because we would have lost our license. But that's the medical records. There's no right to change the medical records, not to correct errors, but to adopt our theory that we are not child abusers before you consent it. There's no right to do that, and there was no barrier to doing that. Thank you for the time.
Thank you. You'll have your fight.
Thank you.
Mr. Tanner?
Good morning, Your Honors. Mike Tanner, Gunser, Yoakley, and Stewart for the Appellees. Judge Smith, I'd like to begin by answering your questions and the two last questions that you asked, and then follow up on the questions that you asked, Judge Black, about the scope of the immunity. But I would like to start out with your last question on when the Kowalskis were told they couldn't leave the hospital. And you heard my colleague say that it's not clear. It's actually very clear. It's at page 3208 of the transcript. And Jack Kowalski testified there that they arrived on a Friday afternoon, October 7th, and he said there that on the following Saturday morning, the next morning, he asked to leave and was told he could not or they'd be arrested. So 3208, and then look at his testimony at page 32 65 and 66, where he elaborates on that. And then, and I think this is important also to your question, you don't need to accept Mr. Kowalski's testimony about that because it's actually in the medical record. Look at the record at R109987. And that is a record by Dr. Voss that was done in the early morning hours of the following Tuesday, after she'd had a conversation with Beata Kowalski that evening, in which Beata said, we want to take Maya out of here tomorrow morning, Tuesday morning would have been the 11th, to take her to an appointment with Dr. Hannah, one of her treating physicians. And Dr. Voss goes in and memorializes in that record what the hospital's response to that was going to be the following morning. And it was that leaving with Maya was against medical advice, and therefore they would not be allowed to leave. And if they attempted to, security and risk management would be called.
And they
Right in the
made a
medical
mistake.
record.
They shouldn't have done that.
And the documents that counsel referred to that show that
They
purportedly
did not have the
Kowalskis
authority to
agreed
do
stay at
that.
the hospital, those are all cited at page 13 of their initial brief. I commend those to you. I want you to read those because what those actually show is that those were all dated the 12th or the 13th, after they'd been told what they were told and memorialized in the record on the 11th. What those show is that the Kowalskis are attempting to accommodate themselves and get along as best they can in the circumstances they find themselves in. And they're agreeing to do some things the hospital is suggesting and disagreeing with other things. But at no point is there anything in the record where they agreed that they would stay there and that that's something they wanted to do. And I just wanted to start off with that. And I will add this as well. I think what you heard this morning was very much like their brief. And what's remarkable about it is the number of factual disputes that they continue to assert and factual issues that they continue to believe that they can litigate here with you in this court. They dispute, for example, that ketamine was efficacious for Maya. They dispute, as you heard just a few minutes ago, that they told the Kowalskis they couldn't leave the hospital. They dispute that they put Maya in the room to video her and that she soiled herself. They dispute that still. They say that it was for medical treatment, yet it wasn't in the medical file.
That it wasn't. It
Counsel
wasn't in the
said to you
file.
this morning that there was an assistant risk manager approved putting her in there. Well, it wasn't an assistant risk manager. It was the risk management department. And we have documents in the file. We
Remember
very
him.
Senior people, very senior people at the hospital who were involved in the risk management department. So I wanted to kind of start off with that to give you a flavor of what we perceive as a very, very factual kind of presentation in the brief and here this morning. And all those issues were submitted to the jury, and the jury found against them on those issues. And yet they want to litigate them again here in this court.
Yep.
So Judge Black and Judge Smith, you asked this question too as a follow-up on what is the scope of the immunity. And I listened very carefully to my colleague here in answer to your question, Judge Smith. Well, what about tortious conduct? Would that be immune? And I think I got a concession that it would be in theory, but then what was that? We have torts here. And that is the jury found torts in this case. And yet we don't have a concession that those torts would be subject to the immunity. We have some other torts, I suppose, that would be. But if you go through their brief, I think the residual point is this. They contend that everything that followed in time from the act of reporting should be immune. They don't say it that way, but if you read their brief closely, look at pages 24 and 25 of their reply brief. I think it becomes clear there. Everything after the act of reporting, they say should be immune. It would be good faith sheltering in their words. So there are two reasons why that's wrong here in this case in particular, but generally. And the trial judge, I think, drew the line very correctly and very carefully between the immune and the unimmune. It's wrong because the statute that we're talking about, and it's 39203(1)A, immunizes certain types of conduct. It immunizes reporting, and the trial judge gave them that. And counsel here said today that they won a certain number of claims. I want to make sure we are talking about who won those. The hospital won those. The the malicious prosecution, the abuse of process, the negligent infliction claims, the interference with parent-child custodial claims, all of those were tossed out by the trial judge on Chapter 39 grounds. So they won those claims, not the plaintiffs. But the trial judge correctly ruled that the things that are immune are the claims and the liability that logically follow from the act by reason of reporting. And so he eliminated all those claims I just described. But then he went on and assessed the remainder of the claims under the remaining language of Section A, which they ignore. And we're asking you and believe that you should apply the full language of the statute. And the remaining language in Section A, and Judge Black, this particularly goes to your question, I think. Section A immunizes reporting, but it then also immunizes conduct that is authorized or required by Chapter 39 and undertaken in good faith. And your honors, there's no such thing as a good faith tort, especially a good faith intentional tort. And nor is anywhere in Chapter 39
good point.
tortious activity authorized or
Good
required.
point.
And so that was the trial judge's
Commit a
analysis,
tort
which
in
we
good
suggest was
faith.
correct. He looked at the nature of the conduct and decided if it's tortious and it's not clearly required or authorized by Chapter 39, then it would be an issue to go to the jury in answer to one of your questions, Judge Smith. So, so that's partly why they want to
Notice
exceed
the judges
statute
are
or
not
ask
interrupting
you
him.
to exceed the statute when they asked for what would essentially be blanket immunity. But the other problem is this: they ignore Section 1B, which goes on to say that any person, which would include a healthcare provider that itself abuses children, is not subject or does not get immunity for any of that. And the trial judge ruled that this kind of conduct, based on the allegations, would fall squarely under that. And that, and the authority for that would be the Yamani case and the Floyd case that we cited. So, Your Honor, I hope that's an answer to your question. I think that's the scope of the immunity, and that's what the trial judge did, and we say he did it correctly. Yes, sir. So, Judge Smith, I do want to also address your question on Nelson. And I think you summarized quite well all the conduct that we laid out in our brief on the application of that case to the IIED claim.
I'm surprised he's even in the
Two
court.
things I would just say about Nelson. In their brief, they predicted that there would be this avalanche of litigation if suicide causation claims were allowed in the state of Florida. Well, that hasn't occurred. Nelson was 43 years ago, and there's been no avalanche of litigation. And I think the trial judge correctly ruled that under Nelson and under the Tate case, which is cited and is the basis of the Nelson ruling, that his jury instruction was absolutely correct, where he gave it a two-prong instruction of the substantial factor, which comes right out of Tate, and also the uncontrollable impulse, which comes right out of Nelson. So you would be following the first district if you applied that analysis and affirmed the trial judge on that instruction. And I will say this as well. Counsel said it again. They said it in their brief that, well, Nelson is an outlier, and also it's based on FELA principles. I think if you read the case, you'll see it's not based on FELA principles. Tate, which it relies heavily on, is a common law case, relies on majority jurisdiction, American civil trial tort principles. And then Judge LaRose, I do want to get to one of your questions. I'm sorry, it took me a while to get there. But you ask, what are the duties of the parents under the shelter orders? And I think it's important.
Specifically, if it were what was the hospital's duties?
Yes, sir. What were the hospital's duties under there? And the trial judge, at the request of the hospital, gave an extensive instruction on that to the jury. And one of them was, Judge Smith, this goes to one of your questions too, the parents were permitted to participate and be consulted on medical decisions regarding Maya. That's right in the order. But the other terms of the orders were that the parents were to have communication with Maya. They were to be allowed to have certain types of visitation with her. The husband and, yes, the father and the brother were allowed communication. The mother was allowed telephone communication at first. Later, that was expanded to allow FaceTime. And they were allowed written communication with her. So, and as we said in our brief, the hospital's refusal or failure to carry those out was part of what we contended was the part of the IIED claims. And those come right out of the shelter order requirements. I do want to address the points he made about Dr. Smith. The fact is,
Where's
they
my
said it in their
Smith
brief.
button?
Dr. Smith did not present well as a witness at trial, and I'm sure they regret calling her. The fact was that the plaintiffs played one deposition clip.
Yeah.
It lasted about 30 minutes. The hospital called Dr. Smith to the stand
Yep.
and kept her there for quite a while. And so if there was any sort of
Big mistake.
prejudice to the optics of the case from Dr. Smith's presentation, the hospital bears the responsibility for that. But I
Yep.
think it's important to remember also that Dr. Smith and her apparent agency was an issue in one claim out of all of these, and that was the medical negligence claim. It was not an issue in any of the other claims. All of the other claims are based on the acts of other individuals and in the hospital, none of whom were shown to have any relationship with the CPT or the dependency court. It was only the medical negligence claim. And the verdict form for the medical negligence claim laid out two questions, or three questions actually. Is Dr. Smith an apparent agent? Yes or no? If the answer to that question is yes, was she guilty of medical negligence? Yes or no?
She
But then
portrayed
it went on
herself
to
as a
say,
JHATS
were
employee.
there any other employees of the hospital other than Dr. Smith whose conduct rose to the level of medical negligence? And they answered that question yes, because there was abundant evidence in the record of other medical practitioners who were involved in the treatment of Maya.
All these
And so
people.
you really don't even
Remember
need to
these
reach,
people?
the issue of Dr. Smith, because the medical negligence
7th floor coven.
verdict is, you can affirm that on the conduct of all of the other doctors. And it was the other doctors in the hospital, Dr.
Remember
Vos,
this guy?
Dr. Teppa, Dr. Dees, who made the decision to terminate Maya's ketamine.
Right.
And that's the basis of the medical testimony that
Remember
Dr.
this
Teppa
one?
testified that it was the termination of the ketamine, which
Bonnie
was an
Rice.
efficacious treatment for her, that permanently aggravated her CRPS. And the hospital has not challenged the admission of that testimony in this appeal.
Just reminding you of all the good memes.
And I also would like to, on a related point to what
Oh,
was going
Daddy.
on in the hospital would like to give you the
Yacht
impression
Daddy.
that
Yeah, Daddy.
everything that was being done to Maya, what she could see, where she could go, who could see her, who she could talk to, all of that was being controlled on a very granular level by the DCF.
Talk about throwing Jesus in the
I want
trash.
you to read the testimony of Catherine Beatty at
Do
pages
it.
3962 through 3970
I have actual
and
evidence of
4000
that.
through 4004.
Cake and
because she was
Jesus.
very clear there about what it was that Johns
No.
Hopkins was dictating, what their discretion was, the decisions they were making through the risk management department versus DC. Yeah.
Why are we doing
And
that?
it's a significant exaggeration to say that DCF was involved in the details of what Maya could do, the scheduling of phone calls.
Connor doesn't know this
kept the
case.
Bathroom door open. That was all done
Oh.
by the hospital.
Connor,
Those decisions
epic.
were made by the hospital.
epic case. I have a whole playlist. In fact, I should add this to the playlist.
I think I've answered most of the questions, if not all of them, that you
There's-
asked.
the
Are there
judges
any
are
other
silent.
questions you would like to ask me at this point? Because there's
Stunned
one final
silent.
point I would like to make, but I want to answer your questions first.
I don't think they
All right,
have
well, let
any.
me-
You don't
let
have
me,
any.
lead with
No
this.
question.
I think
They're like, it's making sense to us.
on the damages, the hospital in its brief more or less went through all of the damage numbers and threw their hands up and said, this is all excessive. There's no evidence that supports any of this. Please reverse it all. Give us a new trial on all of it. More or less, that's what they said. If you look at the damage numbers, and the numbers are large, no doubt about that, but we have to remember that these injuries were done to a 10-year-old child
Mm.
who then would
Mm.
suffer those injuries for the rest of her life, which would be a long life from that point, from 10 years old to 70 or 80. And the medical testimony from Dr. Brewerton was that because of the events at Johns Hopkins, or he uses the term events, she suffered permanent aggravation. She suffers PTSD. And then he said from the experience she had at Johns Hopkins, she suffers major chronic depressive disorder. And that testimony was not objected to by the hospital. And it was not, the admission of it was not challenged as a point on appeal in their initial brief. So that's the medical testimony. The damages testimony was tried as a unified damages case on economics. It was $15 million from Ms. Kirby, and they have not objected to that testimony, and they didn't raise it as a point on appeal in their initial brief either. So that testimony was established by competent substantial evidence, $15 million. If you then take the non-economic award, which totals for all the torts on Maya now, that totals $69.5 million. That's a 4.5 times multiple of non-economics to economics. This court, in the Ailes case on remand from the Supreme Court, left undisturbed a non-economic award that was 16 times the amount of economics. So we submit in that light, and remembering that this was a 10-year-old child, these numbers, even though they're large, look very reasonable. And so again, unless there are questions, we would ask you to affirm, and we stand on our papers.
Give me your full 5 minutes for rebuttal.
Thank you, Your Honor. I want to emphasize that there is a difference between the evidence and the reasonable inferences that can be drawn from the evidence versus rhetorical expansion. And a lot of this case deals with, and something like ketamine efficacy. What are the reasonable, what is the evidence of ketamine efficacy? Maya Kowalski showed up at this hospital having not just been put in a ketamine coma that had her at
Stop saying
science
ketamine
is it's
coma.
milligrams per
Nobody
kilogram
cares.
per hour. But
Dude,
that
don't
coma
even
in Mexico was at the rate of 3 milligrams, 4 milligrams, 5, 6, and 7.
The judges are not going to care about this. Is not what this is about.
Yeah.
The day before she arrived at Hopkins, she was
What a stupid argument.
infused at 24 milligrams per kilogram per hour.
We call this dude
the doctor
Lunchbox.
treating her said, "I'm out. I have failed to treat
This
her.
was already
You need to take her to a hospital.
litigated.
It could be bile
Knock
duct
it off.
inflammation." But this has failed. She rated her pain 10 out of 10, her quality of life 0 out of 10, and she showed up screaming in excruciating pain. Her testimony is that my lesions were returning. The idea that ketamine efficacy is just the law of the case, that this worked and the hospital, ruthlessly just ripped it away to get the mother to kill herself, is conspiracy theory. The evidence, and there's a conspicuous failure to specify what is the extreme and outrageous conduct. I hope the panel is unanimous that there's certainly not extreme and outrageous conduct that is clearly directed at the mother to get her to commit suicide 3 months after she last left the hospital. But things are thrown in there. Maya is asked on the stand, "Oh, did you have conversations during the last 10 days? Did they cut you off?" And she said, "Oh, I didn't even know I had that right." Well, the medical records from December 30th to January 7th reflect 13 interactions between Maya and her mother.
Exactly.
Most of those were video chats. And I want to read into the record. If you look at the record at 108-560, at 111-906 to 910, at 111-915 to 916, at 112-602 through 611. That does not count the times when they called the mother and received no response, which are documented at 108-560-61. So the
He did that on
hospital is
purpose when she
whipsawed
was working.
in
Remember?
the light most favorable
He scheduled
standard does
calls
not
when she
extend
couldn't
to
answer the
making
phone.
unreasonable inferences from the record. Now, they say that risk management made these decisions, and they presented a chart, an org chart that says
You moved
throughout
Patton
the hierarchy, these are all
Oswalt.
connected. Therefore, risk managers are very senior. And you can attribute that. Well, Dominguez versus Florida Power and Light says for punitive damages, you need actions from the equivalent of the president or the primary owner of the company. We have nothing remotely close to that here. There's no basis for punitive damages. And the awards that they're trying to make sound reasonable, there was a battery claim for this social worker who was a grandmother hugging this child when she was crying and upset, and putting the child on her lap, and then she kissed her on the forehead and kissed her on the cheek. Jury awarded $19 million for those hugs. The allegation wasn't she was screaming in pain and she bear hugged her to torture her. This was acts of affection that the child didn't want. Does that state a cause of action for battery? Technically, yes. If my grandmother pinches my cheeks after I tell her to stop, I can sue her for battery. You have bodily autonomy. So there are claims that you can bring in the context of a sheltering case. But to say these awards were reasonable or that there was any basis for punitive damages is wildly off the mark. I want to also...
Can you just clear something up for me? With the reporting that was made initially on October 7th, it did not transpire to anything on the initial report. And the timing of it, they wanted to leave. Would they have been allowed to leave at that point in time?
I think based on the evidence, and we can
When the
assume...
initial report didn't go anywhere.
Correct. We can, on the light most favorable, and Mr. Kowalski's testimony, we can say that it shows the hospital did not allow them to leave or threaten them with arrest and call police officers. The issue then is whether 39-395 authorizes that conduct. And it most certainly does for the first 24 hours. The statute then becomes ambiguous. It says the hospital can detain a child against the parent's will. And that
They
is an
didn't have
express
that
authorization
authorization.
for pediatricians
They
and
did
the
not
hospitals.
have it.
You can take a kid from their parents
You
when they
can't-
say,
they
"Give
didn't
me
have
my
it.
kid," if you think this child is in danger. There's no dispute that the hospital, to their core,
He's
believed
lying.
at all times this
They
child was
needed
in danger
authorization from
in her mother's
DCF.
presence.
They didn't have it.
Now, the court throws out the 24-hour rule, which is a rule that applies to DCF. The hospital can seize and the hospital has to immediately report. It did both. Then DCF has 24 hours to act. And other states write it differently. If you look at West Virginia statute, it says at 96 hours, the power to detain a child expires by operation of law. There are statutes that tell the hospital, you need to let go of the kid. But the false imprisonment here requires unreasonable, unwarranted, and unlawful action. And even if the panel sees 395 differently than we do and says, well, that wasn't lawful under 395, it is still reasonable and warranted that when you think this child could die if she goes out the door with this parent, because we are just terrified. And
But it was okay for them to be transferred, even though those two reports had been made.
to transfer to Nemours?
Nemours.
Yes, Nemours.
That would have been okay under 39, under the reporting, for them to be able to go to another hospital.
Yes, the Nemours was a safe place and had CRPS treatment and psychiatric care. So it checked whatever box.
And any sheltering would have transferred with that, because we're going to a different jurisdiction. I'm just trying to figure out the logistics.
They would have to get approval from the dependency court, and I believe that there was no indication that was not achievable. Yeah, if the parents are in agreement, the hospital's in agreement, I can't imagine if unless DCF objected. But one thing I want to direct court to in my waning time is,
Counsel, I just wanted to point out you're over your rebuttal time, but wrap it up.
if I may, I would
Wrap it
commend
up.
to the court again, the court's January 14th, 2022 order on Chapter 39 immunity. It repeatedly swings and misses on what this immunity is. It expressly and explicitly ties it to reporting and nothing more. That clear error under Special versus West Boca, unless they can show there's no reasonable possibility that error or the other two errors we've identified affected the outcome, we are entitled to a new trial. For that reason, the hospital asked for a new trial that does not include the suicide claims or the fraud claims, and properly applies Chapter 39. Thank you so much for your
Thank you
generosity.
very much. Thank you to both of you. Very well argued. Very sad.
Very sad case.
All rise.
And that's it.
And that's it. That'll be it. So, all right, for those of you who are catching up, who don't know, we are catching up on the Maya Kowalski appeal process. So oral arguments were just heard. Those of you, a bunch of you have questions about this. So let me try to explain. The reason why the judges are different is because this is not the trial judge. Judge Carroll was the trial judge, and Jay Hatch appealed after losing $261 million that they were told to pay up, and they refused to do it. So instead of even settling, offering for less, they offered nothing, and they appealed, and they went to the appellate court. That was the 3-panel appellate court panel that was chosen for this. It's always like this for appeals. You get one shot. You get one shot to go argue, which is why appellate lawyers have to be the absolute best. You get, what, half an hour? Is that what we did? 30 minutes? You get 30 minutes to argue your case, and then they will confer, and they will rule, and that will be the end of it. Now, if Jay Hatch loses, which I expect they will, I think they will lose, because appellate courts don't like to overturn jury verdicts unless there's something really egregious. And I don't see them doing it. They could appeal again. You know, what's after the appellate court? They go to the
Supreme Court.
The Supreme Court of Florida. And then after that, they could appeal to the Supreme Court of the United States. I expect them to appeal all the way. They don't want to give this family a dime. They are horrible people. They are just absolutely awful. They cannot admit when they've done anything wrong. Sorry, I have clips all over my head, but I just got out of the shower. It is what it is. They don't want to believe that they've done anything wrong. They don't want to admit to the public that they've done anything wrong. And even though we can all see that they've done lots of things wrong, and I covered this trial. Those of you who missed this trial, I have an entire Take Care of Maya playlist. You can go back and watch the entire trial with me. I actually met Brad during that trial. Remember Brad?
Mm-hmm.
Good times, man.
So many months ago.
You can fast forward through all the times my computer shut down, and that's when Brad came into the picture. He came in, he swooped in like a superhero, an IT superhero, and he fixed my computer problems. And that all happened during the Kowalski trial. Good times, good memories. Terrible for Maya. Yes, there's been a breakdown in her legal team. Greg Anderson and Nick Whitney, both friends of the program, who I like very much. Both of them have had a breakdown in their relationship. And so the Kowalskis have gone with Nick Whitney as their main counsel, and Greg Anderson is not involved in it anymore, other than, of course, he's going to get paid, hopefully, when Jay Hatch has to pay up
for selling his house and other things.
Yeah, having to take his kids out of private school. I mean, he made amazing sacrifices. Everybody that was involved in this. He was funding a lot of this stuff, doing a lot of work for free. Dr. Joe Corcoran, another friend of the program, he was in the courtroom today, and hopefully I'll get to talk to him. Actually, I should see if he wants to call in. Let me send him a text real quick.
Yes, Rogue Mama, we met a bunch of people through this court case.
Yeah, we did. We met so many people who were involved in this case. Dr. Joe Corcoran, let's remember him for a moment. Dr. Goodhair, I call him. He was the incredible witness in this case who really just destroyed Jay Hatch on their chain of command, right? Their chain of communication was completely broken. And Dr. Corcoran worked in administration in hospitals for years. I loved this meme that I made of him up there on the stand, sipping his water and just destroying Jay Hatch, and finding out that they had these reports, these terrible reports of, let's leave that up there. It's funny. And it's right in between our faces. They had this, what did they call that? What was that report? It was the shutdown report. They were being shut down, and they hid it, and they didn't tell their expert that this report was out there, that Jay Hatch had already been in serious trouble and got an automatic, like an an emergency shutdown order, which doesn't happen unless you're doing really bad stuff. And it turned out that their surgeons weren't washing their hands. They had killed a bunch of kids in the heart
The IJ
Institute or
report,
whatever.
that's right.
Yeah. They were improperly storing oxygen tanks that were explosive devices, like really bad stuff. And they hid that report from their own expert. I mean, yikes. So anyway, Dr. Corcoran has his own story that goes, I remember, Brad, I was watching this case, watching him testify, and I said to the audience, boy, this is the moment I think he realized he's never going to work in this field again. And it's funny, I don't think he knew how true that was until he's been facing his own
Lawsuits.
allegation and lawsuits for being involved in this. It's really sad. And, I hope that the appeals court rules in her favor. But I have no hope that Jay Hatch will stop appealing. Let's get to some of the super chats you guys have here. Jax Mehoff, thanks for the name, by the way. Thanks for making me say that out loud. Thanks for the $2.99. The washing machine slush fund. Yeah, so the washing machine is broken. And I have discovered, my sister, I think, solved the problem this morning.
Oh.
So I have a space problem, and I had to have stackables because my washing machine has to be in my bathroom, and it's the only way it fits is in a stackable. And it has to be, the washing machine has to be upstairs because we have a septic tank. And if I put it in the basement, I have to then install all new system.
Plumbing and wiring. And
yeah. And that will be so much more expensive. So it needs to be upstairs. Well, I am going to separate my washer and dryer. This is what I'm going to do. I'm going to put the dryer in the basement, and I am going to.
Oh, no.
That I'm going to have to go up and down, but you know what? It's better than nothing. I'm going to go and buy a $250 used Kenmore from 1990 something, and I found one. I'm going to go get it, and I'm going to put it in, and I'm going to actually clean clothes with it because it doesn't have a water restriction. And my sister has one. She's been using it for years. She's like, I've put $100 into this machine, and you can always fix it. It's fixable, run forever. And I already found what she found me one. She called around in Rochester and found me one. So I am going to go do that. I'm going to pick it up on Friday. So it's much less expensive than a $1,000 one. But if anybody wants to send me tips for my washing machine problems, I would appreciate it. Super chats are available. So is Cash App and Venmo. Celine von Furstenberg, love your name, by the way. Thanks for the 2. My little laundered fund. Thank you. This is not USAID, but I will take your tips. Cynic in Chief, thanks for the 2. How much do they currently owe with interest? We think it's somewhere around, we think the interest itself is somewhere around 20 million. I'm not sure if Scott of Recovery Addict still has the ticker going, but he had one for a while. Brad, check on Top Mark Media and see if he still has the ticker going. Mike Middleton, thanks for the Canadian 279. I sell washers, insider deal, pickup, Niagara, Ontario. Actually, that's not that far from me. All right, email me, Mike, and let me know. You don't deliver, though. I have to pick it up in Canada. That means I have to get my passport redone. Damn it.
Just chuck it over the bridge.
Can you meet me over the bridge? Cynic and Chief, thanks for the 2. Beata Kowalski Memorial All Children's Hospital. Yeah, she should own it. Kat Buchanan became a YouTube member. Welcome to the Fox Den. It's weird here, but you'll get used to it. Cynic and Chief, thanks for the 5. Jay Hatch is making the same mistake that Dingus and Deuce are making, relitigating the same details they already lost on, and I don't think it'll work. I don't either. The jury was quite clear. Wender Bender, thanks for the 5. I know he's just doing his job, but don't you want to bitch slap this guy? Yes. Rogue Mama, thanks for the... Although I will say he was less frustrating than Ethan Shapiro, who talks like this all the time. And it's like, Maya, why are you wearing such a short skirt to homecoming? It's very inappropriate. I mean, that guy, he doxed a teenager's Instagram pictures. Like, ugh. Rogue Mama, thanks for the 2. Who is this fat David Gingras? Cynic and Chief, thanks for the 2. Wrap it up, especially when she's Laura Owens. Oh my goodness, that was bad. Wait,
you don't wrap blowjobs.
Wait, that's not it. That's
What?
the button I was looking for. Mathis agrees. Thanks for the 2. Megan, did you get the song I sent you? Maybe. I have gotten so many emails in the last couple of days that I have missed a bunch of them, so I'm sorry. Slug Entertainment, thanks for the 2. Since you're 800 years old, I got glass in my foot. Help. What? I suggest tweezers, maybe. I have my favorites. Thanks for the 2. Let's grab coffee when in town. Welsh Lady Reads, member for a month. For all the anger and sadness, you made this case with memes funny and easier to get through. Well, I was just as outraged as everyone else, but the only way to deal with these people is to laugh at them. They are a laughingstock. They should be ridiculed. So here's the thing. I have not read this yet, but I thank you to Mathis for sending me the Kowalski's reply that the judges were referring to when they were asking the questions. I'm not going to bother reading the J. Hatch's appeal because the reply will address every issue in it. But let's read some of this. It's 128 pages. Let's hope some of that is exhibits.
Yeah.
And see what.
Unfortunately, I have to drop. So.
Okay. Ellie, I know I have clips all over my head. Brad, it was good to see you.
No problem.
I know I'm drying my hair. I can't dry my hair if I don't I have to clip up the roots because it helps with the volume, you know? So, yeah. And if I'm not using my, my hair dryer, which I don't have time to do right now, I won't get the volume I want without clipping it up. So this is just the way it is.
Yep.
All right. Brad, thanks for being here.
No problem. See
You're
you
the
guys.
best. I'm thankful for the Kowalski case just because it brought me Brad. And Brad has been such a good and helpful addition to the program. Okay. Statement of the case and facts. So this is the Kowalski's reply to the appeal. The hospital omits necessary facts and fails to view those facts in the light most favorable to the Kowalskis. The Kowalskis therefore provide their own statement. Jack Kowalski became the personal representative of his wife, Beata's estate, following her 2017 suicide. Jack is, and Beata was, the natural parent of Maya and Kyle. When the events described below began in 2015, Maya was 9 years old, and Kyle was 7. Maya turned 11 in December of 2016 while confined in the hospital. The diagnosis and early treatment of Maya's CRPS. Complex regional pain syndrome, CRPS, is one of the most painful neuropathic conditions from which a person can suffer. The McGill Pain Scale characterizes CRPS as more painful than amputation, cancer, or childbirth. The pain is your hand in a hot stove. CRPS is also a chronic lifelong condition which can be aggravated by minor injuries or stress, leading to fluctuating periods of improvement and relapses, with the pain waxing and waning during the sufferer's life. Maya first experienced the onset of unexplained pain following an asthma attack in July of 2015. The hospital treated her for that attack. In September 2015, following months of severe pain, increasing muscle weakness, blurred vision, and ankles turning inward, Maya was diagnosed with CRPS by an award-winning physician who has practiced for more than 40 years and is an expert in the diagnosis and treatment of CRPS. During 2015 and 2016, 4 other physicians practicing in fields of pain management, neurology, and anesthesiology confirmed or concurred with Maya's CRPS diagnosis and treated her for that condition. Their treatments included physical therapy, hyperbaric oxygen therapy, warm water therapy, occupational therapy, intravenous immunoglobulin, and high-dose infusions of the drug ketamine. To facilitate the ketamine infusions, a hospital staff surgeon implanted a port in Maya in early 2016. Maya then, remember when the hospital wasn't flushing her port? And they basically were like kicking her mom out of the room because she was complaining that they hadn't cleaned her port. That has to be, and her mother was a nurse. God, this case was infuriating. Hold on a second. Let me see. Let me check my messages. Okay, Maya then continued her ketamine infusions and other therapies under her treating physician's care. Maya's symptoms steadily improved during 2016. Hospital physicians acknowledged and treated Maya's CRPS during her numerous visits and admissions to the hospital before October of 2016. None of the 20 hospital physicians who saw Maya in 2015 and 2016 raised a concern about ketamine treatments or child abuse. Also, by the way, remember when Dr. Sally Smith, where's my button? Remember when she had to use Google and YouTube to find out what CRPS was? Does that seem like appropriate medical diagnosis to you? Google. Maya's October 2016 visit to the hospital and the first report of child abuse. Maya's CRPS flared up in August and September of 2016, after her treating physicians increased the ketamine infusion dosage to address the flare-up. Maya experienced severe gastrointestinal problems. On October 7th, Maya's doctor recommended Jack take Maya to the hospital's emergency room. Beata met them there. The hospital's staff lacked extensive clinical or academic experience with CRPS. That's right. They had to look on Google. They telephoned one of Maya's physicians who confirmed the CRPS diagnosis and his recommended levels of medication, including ketamine. The hospital's staff were skeptical of these recommendations and debated with the Kowalskis about the proper ketamine dosage. And again, the biggest argument during this case for me was, if you think that the prescribed recommended medical treatment is abusive, why are you going after the parents and not the doctors? Why did they go after the parents and say, you're abusing this child, when all they're doing is following the instruction of other doctors? It's crazy. It was crazy. So they debated about the proper dosage of ketamine, at first providing a much lower dose of ketamine and eventually eliminating Maya's ketamine infusions. The hospital staff and physicians also required Maya to do physical therapy and undertook other procedures, which hurt her, by the way, such as CT scans and inserting a breathing tube that required physical contact with Maya's body. Maya also reported that nurses kept touching her on purpose, like touching her legs and stuff, and that's where she has the most pain. And they would just walk into the room and be like, how are you doing? And touch her leg. Like with no, either they were doing it on purpose or just had no understanding of what CRPS is. So upsetting. If you're just getting here, we did just carry the appeal oral arguments for the appellate hearing, and that was in the beginning of the program. You might want to back up and see those. I think that Maya's lawyer killed it. The judges indicated that they didn't buy Jay Hatch's story. They weren't buying those arguments. They had a lot of questions for him, almost zero questions, maybe no questions for Maya's attorney, which is always a sign that you're on the losing side if you get all the questions and the other side doesn't. As is common with CRPS patients, these caused Maya severe pain and inflamed her CRPS. So did all the emotional distress, by the way, when they took her from her parents. Maya told hospital personnel that this was painful for her, based in part on Jack and Beata's requests that the hospital provide Maya the prescribed ketamine treatment. A hospital social worker contacted the Florida Department of Children and Families DCF Child Abuse Hotline on October 7th. Although DCF opened no investigation at that time. They were like, nope, not going to do it. There's just an argument between doctors. We're not getting involved. Right? The next day, October 8th, Maya's severe pain continued, as did the hospital staff physician's refusal to administer ketamine, prescribed by Maya's treating physician and requested by her parents. Jack and Beata asked the hospital to discharge Maya, but were told that if they tried to leave with her, they would be arrested. And that was false, by the way. They lied. They didn't have the authority to have them arrested because, as you just read, DCF failed to open an investigation. And that means that they had all their 14th Amendment rights still in place to parent their child the way they see fit. And they were allowed to walk her right out of that hospital. They had no DCF involvement at that point. And this is when the kidnapping comes in. This is actually a great recap of the case. I'm sorry I didn't read this before. I've just been really busy with other stuff, you know? The Hales case is just like outrageous. Hale's case just keeps getting weirder and wilder. And tonight I'll be on with Tug on my channel. And I'm sure I just wait till 5 or 6 p.m. to see what we're going to talk about because things keep getting filed on a daily basis. All right. Dr. Corcoran cannot pop in with us right now, but he says we can connect later in the week. Okay. All right, cool. Okay, let's see. We're told if I tried to, okay, they were told they would be arrested if they tried to leave with her. During this time, hospital staff discussed Maya's care with the hospital's risk management department. That was this guy. Remember this guy with the face? This guy who claimed, I don't know nothing. I don't know nothing about nothing. I don't know. It wasn't my job, which it totally was his job. This trial is so worth going back to watch. And in fact, I'll tell you what we will do. I don't know if I'll get through this entire thing, but because it is 128 pages. But I'm going to set a super chat goal. And if we hit it, for those of you, we will rewatch Sally Smith's testimony since they brought it up about how bad she did. And even Jay Hatch's attorneys were like, well, she had like a rusty smoker voice, which, by the way, let me get my Sally Smith voice on. So, I'm a child abuse doctor. My name is Sally Smith. I smoke 40 cigarettes a day, and I drop kids. That's what I do. I drop them. Pick them up and drop them. Remember her? Remember her? Oh my God. Oh, it didn't work? It didn't work? My Stream Deck is acting weird. That's too bad. Doesn't work? Huh. That's too bad. I can't do it. That's my regular voice. Well, anyway. My thing isn't working. Oh, you know what? It's probably because you had me do something weird, Slug, to my voice mod. Didn't you? This is your fault. Anyway, we'll get back to it. Anyway, here's what we'll do. If I'll set a goal, we'll make it a small goal. We'll do 20. All the colors. And if we get 20 in the next 30 minutes, we will rewatch Sally Smith testimony, which was so bad. It was so bad. All right, there we go. I'm starting it now. Okay. All right, let's keep reading this. I think it's funny that Jay Hatch knows how bad she was, though. For the love of the traveling Mary. Jackie Beata asked the hospital. Okay, we did that. During this time, they discussed it with risk management. Also on October 8th, when there still was no open DCF investigation, hospital staff contacted Dr. Sally Smith, one of its staff physicians. Dr. Smith was also director of the Pinellas County Child Protection Team. Beginning on October 8th, the hospital gave Dr. Smith full access to Maya's medical records without her parents' knowledge and consent. And again, remember, DCF had not opened an investigation. There was still no open. See what this says here? Still no open DCF investigation. This woman was rooting around in medical files she had no business being in. None. Zero. Zip. Nada. Beginning on October 9, Jack and Beata again asked the hospital to transfer Maya to another healthcare facility or release her so she could be treated by one of her regular physicians. This is a totally reasonable ask, by the way. They're like, we don't agree with you. You don't agree with us. Send us to another institution, please. Let us transfer someplace else or release her so that we can go to her doctor. Okay, I got to move the clip now because that back part is drying. No, this clip is too heavy. I need a lighter one, but I don't have it. Okay, wait. Is this not working? It's hard to do this. There we go. I know it looks crazy, but I could turn the camera off, but then you wouldn't be entertained. This is how you dry curly hair. You have to clip it up. Let's see. I can probably move this one too. Oh, yeah, that one's doing okay. I'll move this one over here. There we go. Wait. This is difficult. Okay, there. All right. On October 9th, yeah, we did that. That day, a hospital social worker again contacted the DCF child abuse hotline and reported suspected child abuse by Maya's parents. On October 11th, Jack and Beata again asked to leave with Maya to take her to another physician, and once again were threatened with being detained by hospital security or arrested if they tried to leave. This violated the hospital's discharge policy that allowed patients to leave the hospital against medical advice, AMA, and caused Jack and Beata extreme stress. This one's falling because it's not the right size. That one's not going to work. The hospital did not inform Jack and Beata that it lacked authority to detain Maya. It also did not inform them of its patient and family rights and responsibilities policy, which states that the patient and family have the right to ask for a transfer to another healthcare provider, providing it's medically acceptable, and the other provider will accept your transfer. Isn't that unbelievable? They have that written in their policies, and they wouldn't do it. Yeah, Sticky, Sally Smith totally does sound like a made-up name. I agree with you. What does this say? Welsh lady says, Sally Smith, just to see the binders again. Oh, yeah, the binders. And I forgot about the lightning bolts. Oh, my God, the lightning bolts. That's right. Who were they accusing of using Nazi symbolism for using the lightning bolts? I don't remember. It was from an album cover. It was from a Kiss cover. But who was it that they were accusing of? I've totally forgotten, but there were so many weird things in this trial. It's totally worth the rewatch, you guys. Let's see where we're at. We're at 3 out of 20 super chats. So you guys have there's a bunch more to go. Okay, here we go. Let's see. Where do we go? To ask for a transfer. Okay. The hospital's discharge of patients against medical advice policy also stated if the patient family insists on leaving, they must be permitted to go unless their departure puts the patient's physical or mental health in imminent danger. And if you were transferring to another medical facility, then that clearly wouldn't be the case. Jack first met Dr. Smith on October 13th when she came. Wait, I forgot my button. When she came to Maya's hospital room without introduction or disclosure of her role as a CPT representative. She was wearing a hospital lab coat and a name badge, which led him to believe that she was another hospital physician there to provide medical care for Maya. Based on the hospital's second report to the child abuse hotline, DCF filed dependency proceedings on October 13th. So remember how much time went by. They called on the 7th. They said no. They called again on the 8th. They didn't open an investigation. They called again on the 9th or 10th. Then Sally comes in, still no investigation. Sally comes in, starts messing with going into the medical records and investigating. She's investigating before there was a DCF investigation. The investigation doesn't start until October 13th. So between, the 7th and the 13th, they did all these things that were illegal. Yeah.
She lied?
Yep. On October 14th, the dependency court placed Maya into DCF's protective custody, effective as of 2:30 a.m. on October 13th, and designated the hospital as Maya's shelter location. There was no dependency court shelter order entered until October 14th. The dependency court later modified the October 14th order. These shelter orders were not placed into evidence. Instead, over the Kowalski's objection, the trial court instructed the jury on the order's terms as summarized below. The hospital is immune from any civil claim based on reporting suspected abuse, but not for any of the claims being presented to the jury. Before October 14th, 2016, there was no dependency court order governing Maya's hospital stay. From October 14th through January 13th, Maya could not be discharged from the hospital without dependency court approval, and the hospital is not responsible for the length of Maya's hospital stay or Beata's inability to visit her. I personally think that this is all garbage and immunity should never have been given, but her lawyers were able to get around this and get to the hospital and through other means, which they should have, because the hospital was terrible. But I mean, the state should be held accountable for this too. The state did not do, this was not a proper investigation. Sally Smith ought to be held accountable for everything she did. And so should the state agency. The dependency court's placement of Maya in the hospital did not, and this is important, limit her parents' rights to be informed about and participate in decisions concerning her treatment. Beata was permitted to exchange written materials with Maya and have supervised telephone calls with her. Maya was allowed to have religious artifacts that did not interfere with her rehabilitation. And what did they do? They threw Jesus and chocolate cake in the dumpster. Literally, they took her consecrated wafer that a priest gave her and threw it in the trash. And they claimed that her mother had somehow put ketamine on it. That's their excuse for that. They threw it in the trash. They wouldn't let the traveling statue of Mary stay in the hospital. They kicked that nice lady out, the one who brought Mary. This is a very Catholic child. They wouldn't let her have holy oil, holy water. They said her mother had put ketamine in it. They never tested it. They never verified to see if that was true. They just kept this child from having any of her religious artifacts, and she couldn't have her family. They threw Jesus in the trash. Sweet baby dumpster Jesus in the trash. And those of you who don't know, for Catholics, a consecrated host is the body of Christ. And in order to dispose of it, you have to give it to a priest to dispose of it properly. If you drop in Mass, if you drop the host on the floor, everyone goes nuts. You have to pick it up, make sure there are no crumbs, put it in your mouth immediately. This is why the priest, when they break the bread, they actually scrape the plate of the crumbs into the wine and drink it, because not even a crumb can end up on the floor. That's how important it is to Catholics. And they threw it in the dumpster. I want to put that out there. I want to get that seared into your brains that they took her communion. She wasn't even allowed to have her communion, and they threw it in the trash. This is one of the worst things I've ever heard anybody ever did to anybody. And we're not even at the bad part yet. And the dependency court encouraged the hospital to allow a Catholic priest to have regular contact with Maya, and they didn't allow it. It would not let her priest in the hospital. I mean, these people, Beata was permitted to have video contact with Maya at times and under conditions approved by the hospital. A later order specifically allowed daily video calls at approximately 11 a.m. and 5 p.m. and did not require the hospital to supervise those video calls. But they did anyway. They kept supervising when they didn't need to. And then they would interrupt her. They wouldn't let her pray. She got interrupted when she would pray with Maya. How sick is that? These people are sick. This is why we called them the seventh floor coven, because they were a bunch of witches who were trying to keep Jesus from a little girl in pain. These are the seventh floor witches right here. Well, almost all of them. The one in the pink shirt is the DCF lady that threw Jesus in the dumpster. Sally Smith is up there in the top left corner. She's a lovely woman, isn't she? This is what they really do at JHatch, imprison kids. Okay. At the hospital's request, The court read the instruction to the jury during the trial and included it in the jury's packet at the end of the case. All right. Connor, your dad came up with "Sweet baby dumpster Jesus." That was his favorite line. Sweet baby dumpster Jesus. Jeff and I did this. We covered this case, a lot of it together. And it was a good time, man. It was a really good time. Good case. Yep. Turn that dumpster into a holy dumpster is right. While Maya was in its custody, the hospital's treatment team decreased and terminated the medications prescribed by Maya's treating physicians. The hospital team discussed Maya's medical treatment with Beata, including her prescribed medications and the possible removal of Maya's port, which Beata objected to. Dr. Smith agreed with terminating Maya's medications. Dr. Smith also ordered, without parental consent, allergy and other laboratory tests on Maya and consulted with other hospital personnel about removing Maya's port. The hospital's medical record and trial testimony reflect Dr. Smith's role in creating and being part of Maya's multidisciplinary, interdisciplinary care team. Dr. Smith's text messages show that she was in frequent contact with other hospital physicians, yep, they sure do, about Maya's treatment. Let's put this on the other side. I feel like I don't have enough lift over here. Okay. During Maya's 3 months in his custody, the hospital gave Maya less than 5 hours of cognitive behavioral therapy. Less than 5 hours, which is the therapy they said that she should have. And they gave her, in 3 months, less than 5 hours. My God. One of 3 general modalities for pediatric CRPS. By contrast, during 2 weeks of CRPS treatment at Tampa General, in August of 2015, Maya received 5 hours of cognitive therapy. In 2 weeks, she got 5 hours. Oh, that's an interesting comparison. So what they're saying there is, look, she was at this other hospital for 2 weeks and she got 5 hours. She was at JHatch for 3 months and only got the same amount she would get in 2 weeks. Unbelievable. I know, Flux, I feel the same way. This is making me mad all over again. I'm getting steamed about it, and we should be. This case, the fact that JHatch is trying to keep her, this family is probably already close to bankruptcy after trying to fight this and spending millions of dollars to fight this. And they're just refusing to give any money. They wouldn't even sit down at the settlement. The ordered settlement that Judge Carroll required them to do, they got there and were like, no, fuck you. We're not gonna give you anything. Although the dependency court ordered family therapy sessions, the hospital did not provide this. Interesting. They were trying to keep them apart. The hospital's efforts to show CRPS was a charade. The hospital personnel, including Dr. Smith, were skeptical of Maya's treating specialist's CRPS diagnosis and rejected their treatments as absurd, openly suggesting to Maya that her pain was all in her head and that she was performing a charade, and that Beata had mental issues that were harmful and life-threatening to her daughter. They sure did. The hospital's medical record repeatedly referenced Munchausen by proxy, also called factitious disorder, a psychological disorder implicating Beata in child abuse. Despite Beata not being diagnosed with this disorder, they always do this. You don't have to be diagnosed for them to accuse you of it. It's awful the way that they do that. The hospital refused to transfer Maya to another facility unless the Kowalskis agreed to it in the required transfer form. Hospital personnel referred to Maya as the ketamine girl. In a text message to a hospital colleague, Dr. Smith said, "I wouldn't put anything past her mother." She also texted that Maya was making physiological mistakes because, fortunately, at 10 years old, she can't perform the charade effectively 24/7. For approximately 48 hours between October 18th and October 20th, with prior approval from the hospital's risk management department, Dr. Smith and other hospital personnel placed Maya in a room used for EEG monitoring to secretly videotape Maya without her parents' knowledge or consent. Hospital notes reveal that Maya was put there and surveilled to see if she can walk on her own. and what she was able to do when no one was there. The notes confirm the secret surveillance received an okay from Risk. Yeah, from this guy. And by the way, they put her at risk of falling, and bad things did happen to her there. And they didn't put it in her record. So her record, this did not have a medical reason to do this. There was no medical reason, and they didn't include it in her medical records. This was just on handwritten notes that they found through risk management. Do you remember that? The handwritten notes? Horrible. As part of this scheme, hospital personnel placed the room's only toilet out of Maya's reach. When hospital personnel ignored her calls for help to go to the bathroom, Maya was forced to soil herself. When they did respond, they lifted Maya from her bed to the toilet and back, her atrophied legs dangling. The hospital states Maya did not soil herself, an example of it construing disputed facts in its favor. Although the hospital says the full video shows no soiling in bed, each party showed the jury only 4 clips each, not the full video. The hospital now states the video was for clinical and diagnostic reasons, yet neither the video nor the hospital's staff notes were put in Maya's medical record. During this time, Maya's severe CRPS pain returned, reversing her previous progress and controlling the disease. Although hospital physicians disputed that Maya suffers from CRPS, the hospital billed the Kowalskis' insurance carrier Aetna over $500,000 to treat that illness, of which Aetna paid over $300,000. How is that not insurance fraud? They kept claiming, well, it wasn't insurance fraud. It wasn't. But they kept saying she didn't have it. They took her away from her mom for saying she had it, and then they billed the insurance company for it. The hospital's other efforts to break the Kowalskis. After entry of the shelter order, the hospital's employee, Catherine Beatty, remember her? The one who wore purple all the time. There she is. She is on the second row, second from the left, with the cross around her neck. It's probably upside down. Catherine Beatty. Oh God, I couldn't stand this woman. The hospital's employee, Catherine Beatty, was assigned to its primary social worker, overseeing Maya's sheltering. All right, let me check on our super chat goal. How much more time do we have? We're only 10 away. Only 10 more, and it doesn't tell me how much time we have left. I don't remember when I said 30 minutes. But we're only 10 away. If you want to rewatch Sally Smith's terrible testimony with me, 10 more super chats to get there. Okay. And don't forget to like and subscribe. Do not forget to do that, because I am looking forward to getting to 75,000, and I think we can do it. I think we can do it soon. So make sure that you do that. Make sure that you like and subscribe. And if you can send a super chat, do it. If you can't, then don't. Because I don't want your ramen money, for sure. I don't want that. Only your Starbucks money. Okay. While Maya was in custody, the hospital disciplined Beatty for threatening behavior toward other employees. A hospital expert witness agreed that Beatty's behavior on that occasion had been aggressive. Although Beatty had been counseled twice before about her behavior towards colleagues, the hospital let her oversee Maya. Oh my God. Why would they do that? These people have the worst personnel problems. Hospital personnel kept Jack and Kyle's visits to Maya brief, and occasionally Beatty or other hospital personnel turned Jack away without explanation. And by the way, Jack was under no restrictions. He was supposed to be allowed to see her whenever he wanted to, because the charges weren't against him. They were against his wife. Nobody accused Jack of having Munchausen. Nobody accused Jack of faking anything. Although the shelter orders allowed Beata to visit Maya by telephone or FaceTime, Beatty often interrupted their conversations, limiting what Maya and Beata could discuss to very basic and insignificant things. Beatty often made facial expressions to Maya, denigrating Beata during these conversations. Beatty sometimes refused to allow Maya and Beata to speak at all, including on Thanksgiving. And she refused to schedule any phone or FaceTime calls during what became the last 10 days of Beata's life. Hospital personnel, this is so sad. It gets so bad, you guys. Hospital personnel also refused to give Maya a white dress that Beata sent as a Christmas gift, despite having received it weeks earlier. They even refused to give Maya a birthday card from her family. During Maya's sheltering, yeah, we didn't even get to the part where they stripped her for photos yet. Yeah. During Maya's sheltering, hospital personnel prohibited or limited visitation by family friends, and one of Maya's treating physicians, Dr. Hannah. Because Maya was not listed in the hospital's computer as a patient, it was difficult for visitors to see her. They hid her. In her room. Remember, she didn't even have her name on the room. They hid her. In addition to limiting or denying Maya comfort from family and friends, they also denied her spiritual comfort by preventing the family's priest from visiting and praying with Maya, and members of the Kowalskis' congregation from presenting Maya with a religious statue. They also confiscated Maya's prayer book, rosary beads, cross, communion wafers, and holy water. Maya compared being there alone as feeling like torture caused by the hospital's violations of its Bill of Patient Rights. Hospital personnel also prohibited Maya from using a laptop computer that the school district provided to her to access her coursework. And by the way, she was a very gifted student, and she did not want to fall behind at school, and they weren't letting her use the computer. They said she was going to communicate with her mom. Who cares? She was allowed to communicate with her mom. The court said so. Beatty prohibited Maya. Oh, Beatty told Maya this was because Beatty feared I was browsing sex websites. Are you kidding me? Beatty prohibited Maya from socializing with other children on the hospital floor. She also required Maya always kept her room door open, even when seeing visitors, including her attorney showering or using the toilet. Beatty made disparaging remarks to Maya about her parents and asked Jack if he had considered divorcing Beata. She told Maya falsely that Beata had been placed in a mental institution and that she, Beatty, would become Maya's mother and foster her. These are sick people. The hospital saying Beatty allegedly suggested that Jack divorced Beata is another example of its construing disputed facts in its favor. The jury believed Jack. That's right, they did. And by the way, I confirmed for you guys, that absolutely happened. They do it all the time. DCF always does this. They tell one of them, the parent who's being accused of something, they tell the other parent, if you just leave, if you divorce, then you can have your kids back. It's like they like breaking up families. Beatty was the hospital social worker. We are only 6 super chats away from rewatching Sally Smith's horrendous time on the stand in the Kowalski case. So if you would like to see that, send in a super chat. Helps the show, and I will rewatch it with you today. It'll be great. Okay, where was I? I got to get back to the right screen. The hospital ignored the family's concerns about Beatty's involvement with Maya and ignored their requests. See how it works? The clipping works. See, like now I have to do over here. See, this one needs it. I need a bunch more of these. I need to go get some. I keep losing them. They like, I don't know. They fall on the floor and roll under things. They ignored the family's concerns about Beatty's involvement with Maya and ignored their requests to remove Beatty from Maya's supervision. Except for limited contact with her immediate family and with Beatty and other hospital personnel, Maya, a 10-year-old child, that is the age my son is now, I would go crazy. Like I would have gone absolutely mad. I mean, I may have had the same reaction as Beata. Who knows? If they're holding your child hostage, blaming you for something you know you didn't do, and torturing them, Beata knew the only way that they were going to let Maya go is if she was out of the picture completely. And that's why she did what she did. Except for limited contact with her immediate family and with Beatty and other hospital personnel, Maya, a 10-year-old child, was alone during her 3+ months of protective custody. I like that it's in sarcastic quotation marks, all while being told she was faking it, making it up, and her illness was in her head. This is a wonderful document. I wonder who wrote this. Did her appellate lawyer write this? Probably. Maya testified her physical condition worsened during her hospital stay. The hospital's battery of Maya On multiple occasions, Beatty made inappropriate and painful physical contact with Maya by sitting Maya on her lap, slapping Maya's legs to see if it caused pain, holding Maya, clawing through her hair, and kissing her on the cheek and forehead without permission. Oh, gross. On January 6th, at Risk Management's direction, Beatty and a nurse forcibly stripped Maya down to her underclothes and photographed her while restraining her on a gurney. I will never get those pictures out of my head. I unfortunately still remember them, and the look on her face was so bad, was so sad. I just can't. The idea that these people could get away with this if the appellate court rules the wrong way makes me sick. They should never get away with this. Although Maya cried out and protested, Beatty threatened that if she continued to resist, she could not attend a dependency court hearing that morning to see her mom. The hospital admits it did not obtain parental consent to photograph Maya. These photographs, which the hospital argued it took for medical reasons, were never placed in Maya's medical record. What they were taking them for was the lesions, allegedly. They were trying to get pictures of, they were trying to see that before she went to court, that they thought she was doing it to herself, or that Beata would somehow put lesions on her. Like, how would Beata get in court, get access to this kid to put marks on her? I mean, it's absurd. It's absolutely absurd. All right. The active involvement of the Risk Management Department in upper management. The Department of Risk Management is a department of the hospital's parent entity, All Children's Health Systems, Inc. The department works collaboratively with the parent entity and all of its subsidiaries to analyze, manage, and reduce risk, as well as to enhance clinical patient care and protect the parent entity's assets and reputation. Yeah, you know what? I forgot how bad this case was. We hit it. We hit our goal. Okay, cool. We did it. Thank you, guys. We will definitely rewatch that today. I don't know how much more of this I'm going to read because it's 128 pages, but we'll see what we can get through with. The department works collaboratively. Okay, we did that. The ultimate authority and responsibility for the ACHS Department in Risk Management rests with the governing body of All Children's, which delegate authority through the ACHS President, CEO, and Director of Risk Management. A risk management committee provides direction and oversight to the Department of Risk Management. During Maya's sheltering hearing, the risk management committee consisted of the hospital's chief of staff, vice president, medical affairs, vice president, chief operations officer, vice president, chief nursing officer, Johns Hopkins Health System senior counsel, and director of risk management or designee and one or more licensed risk managers. The court admitted the document showing the foregoing over the hospital's relevance objection. The risk management department members within the hospital reported directly to the hospital's senior counsel, its chief legal officer, who reported directly to hospital's president, chief, okay, blah, blah, blah. So the CEO had a direct conduit of information from risk management. The risk management department's notes show that it was aware of what was happening to Maya and how she was being treated by hospital staff, including Beatty. For example, an email from a risk management department analyst characterizes Maya's scratches and lesions as self-inflicted. Beatty testified risk management approved photographing Maya on January 6, 2017. The risk management department also received reports that Maya felt she was being lied to by hospital personnel. Dr. Paola Dees, Dr. D's nuts, testified I had contact with what I would perceive to be upper management without a definition on at least one occasion during the 2 weeks that I took care of Maya. Beata's suicide caused by the hospital. And again, guys, this stream is going to be demonetized because I refuse to say stupid words like unalived, and so they will demonetize it. I won't be able to turn the monetization on. So keep that in mind. If you want to support the show and hear words as they are and not stupid words we have to make up because of censorship, support the show. Hospital personnel knew Beata was under significant distress, was emotionally fragile concerning Maya's health, and had suicidal thoughts. Yet they frequently suggested to the Kowalskis that Beata was harming Maya. Jack told Beata that hospital personnel were unresponsive to Maya's needs and were telling Maya her symptoms were all in her head. Beata was desperate for information about Maya, being especially concerned about Maya's health and the hospital treatment team's reduction of Maya's prescribed medications. Maya told her mom she was hurting and hoped she could see Beata soon. As Maya's CRPS symptoms were worsening, she continued deteriorating. Jack tried as much as possible to tell Beata every single thing he knew or learned about Maya. Oh, and by the way, they actually were like, well, he shouldn't have done that. I'm sorry, what? He's going home to his wife every day and he's the only one who can see their kid. He wants to know, how is she? She wants to know that. What, are you kidding me? He's not supposed to tell her? It's his fault because he's telling her what's going on at the hospital. It's not the hospital's fault for doing it. Give me a break. Man, if I were in this situation, imagine and trying to explain to your son or daughter why they're being held. And whenever Beata would try to say something about the court won't let me, the court is making this happen, they would cut her off and say, you're not allowed to talk about that. You're not allowed to tell your child why you're being kept from her. I would lose my damn mind. He made sure Beata knew what Kathy Beatty was doing. Jack told her about the secret video recording of Maya, Beatty's batteries of Maya, Beatty's refusal to deliver the Christmas dress Beata sent, Beatty's statement that Beata was in a mental institution, and Beatty's advice that Jack divorce Beata. Jack described Beata as very upset and outraged at this conduct, but feeling there was nothing she could do about it. Beatty's interference with Beata's phone conversations with Maya destroyed Beata. Maya's mistreatment by Beatty at the hospital led Beata to continue to grow more desperate, and it ultimately crushed her. The hospital's conduct caused the Kowalskis great and lingering emotional pain. Jack described watching Maya and Beata deteriorate. Beata's grief manifested itself in growing desperation to rescue her daughter from the hospital's abuse. One hospital physician, Dr. Teppa, noted Beata has expressed suicidal thoughts. After Beata's death, another physician, Dr. Laura Vose, remarked that she had predicted Beata's suicide. That's how awful these people were. They actually knew it was coming. They knew they were driving a mother to kill herself, and they continued doing what they were doing. They should be in jail. Forget about the $260 million. They should be lucky they're not in jail. In a just world, they would all be arrested for this. Beata committed suicide at the family's home on January 7th, 2017, the day after they stripped her daughter naked and took those pictures. 2 days later, Dr. Smith texted a hospital treatment team member about what to do with Maya going forward. Her text ended with the craziest case ever. Another hospital physician even suggested Maya might have a better life without Beata. The hospital participates in federal funding programs. Oh, by the way, something that didn't come up in the trial, that did come up when we were reading the juvenile transcripts, or maybe it came up in the documentary, but not the trial. Beata passed out, like lost consciousness at the dependency hearing when the judge ruled against her yet again and had like a medical event. And that was not too long before her suicide. Yeah, it's the worst case I've ever... I've forgotten how bad it was too, Rogue Mama. I mean, oh God, so many evil people. This is what I was talking about, the immediate jeopardy status. So maybe we don't have to read all of this, but remember, in 2019, they were put on immediate jeopardy status, the most serious classification for a hospital because it was out of compliance with one or more conditions, the health and safety conditions. Okay, we don't have to read all of this. They confirmed it. We know it's true. They replaced their CEO. Their new leadership acknowledged deficiencies. They didn't tell their expert witness. He misled the jury. The trial court thereafter observed the hospital has given the impression to the jury that everything was fine, and I'm being presented with evidence that during the relevant period of time that your expert testified that it was fine, that it wasn't fine. Remember how mad he was? The court therefore allowed the Kowalskis to conduct a mid-trial discovery from the hospital and then present evidence of the immediate jeopardy notice to the jury. The termination of dependency proceedings. So at this point, they dropped it after Beata committed suicide. This is what they found. They basically found that everything that Beata said was true, that she did have CRPS and excruciating pain, that they sought ketamine, and that the hospital refused and accused Maya's mother of factitious disorder by proxy. Okay, we already know all of this. These conclusions were consistent with the same psychologist's earlier evaluations of Jack and Beata that found no evidence that either parent was harming their daughter. On January 13th, just 6 days after Beata's suicide, the dependency court discharged Maya to Jack's custody and terminated the visitation orders. The dependency court terminated her shelter status on April 20th, 2017. But, by the way, they made him sign a piece of paper that said he would not get her ketamine therapy for the rest of her childhood. So she was not allowed to have the only thing that ever worked for her until she was 18. And even then, she's probably scared to go seek it out. Who knows? All right. So pre-trial proceedings. The Kowalskis filed their initial complaint on October 5th, 2018. The case was tried on their 8th amended complaint. The hospital filed nearly 50 motions to dismiss or motions for partial or final summary judgment. The trial court either dismissed with prejudice or granted summary judgment in favor of the hospital as to 21 of the Kowalskis' claims. Then we had the immunity order. We don't need to go over that. We know about that. And if you don't know about it, it's just that DCF got immunity. Punitive damages proceedings. False imprisonment battery. This is just going over what happened. The case went to trial. We know this. Kowalski's moved in limine to exclude any mention of Chapter 39 and its immunity provisions. The trial court denied that motion, but prohibited all parties from introducing details about the dependency proceedings. At the hospital's request, the trial court read the jury a 10-page special instruction describing the Kowalskis' visitation rights and the hospital's duties under the dependency court's orders. They presented evidence showing the above facts and specific evidence related to the hospital's appellate issues. Catherine Beatty. The risk management department directed Beatty to keep it up to speed on Maya's status. Beatty agreed the risk management department was fairly involved in this case. She said it was up to risk to interpret the DCF shelter orders and what we were supposed to do and not do. The limitations she imposed on Maya's visitation, meals, and other activities, such as keeping her room door open, actually came from the risk management committee, she claimed. Regarding to the photographs taken of Maya when she was forcibly disrobed, Beatty testified, "I was just directed by risk management to do that." Beatty acknowledged Maya's parents were not asked permission for that, and they did take she admitted they took the photos over Maya's objection. Unfortunately, we did, she admitted. Oh. Santos S. Bifulco. Dr. Bifulco is a medical doctor specializing in physical medicine and rehabilitation, certified in life care planning. Oh yeah, okay. This is all about calculating what she should get. In her life care is going to be very expensive. That's all that it's about. Let's move on. She has got PTSD because of this. We can just imagine. You can imagine how she's psychologically affected by this. I'm gonna skip down here and see. Okay, so we have Dr. Corcoran, we have Jack. We know about. I think we've gotten the gist of it for those of you who need catching up. on what happened in this case. We've gone over enough of that. So I may read through the rest of that at a later time, but I promised we got the super chats, so we are going to watch together. Sally Smith. Look at my roots, man. I need to get my grays worked on. They're getting worse. It's terrible. All right, let's see. Dr. Sally Smith. Testimony. Is this the whole thing? Is it only 24 minutes? That would surprise me. Yeah, I think it is. This is Court TV's. Oh, no, it's more than that. Okay, it's an hour. That's what I thought. All right, when does she get on the stand? Here she is. All right, let me pull this up. All right, and before I start this, I need to go get some coffee because I need an extra cup of coffee. Well, I'll just let it play. I'll go get my coffee and I'll be back. Okay? Make sure you can hear it first, though. Here she comes with all her binders of incantations and spells or whatever the hell she's got in there. Binders full of stuff.
I do.
All right, I'll be right back.
Morning.
Good morning.
Tell us your name, please, ma'am.
Sally Marie Smith.
And what is your occupation?
I'm a pediatrician.
And where do you presently practice your profession?
I'm a partner in a pediatric general practice in St. Petersburg called Fifth Avenue Pediatrics.
And you have several other pediatricians that work with you in that practice?
Yes.
Okay. And that's basically a private practice of pediatrics?
It is.
Okay. Would you give the jury a brief, I think the jury's heard some of this, but if you give the jury a brief overview of your background and training in your profession, please.
Okay. My undergraduate degree was Bachelor of Science in Biology from Georgetown University in 1980. I went to St. Louis University School of Medicine and graduated in 1984. Pediatrics is a 3-year training. And so I did my first year and a half of my pediatric residency at what was then All Children's Hospital. And then I moved back to St. Louis and completed my residency at Cardinal Glennon Children's Hospital, which is the children's hospital affiliated with St. Louis University. And I did an additional year of training in what they call ambulatory pediatrics. I sort of had a career path trying to be a teaching general pediatrician. And so that was the focus of that additional year of training.
Okay. And did there come a point in your career at which you became interested in child abuse pediatrics?
Yes, actually, when I was in medical school.
Okay. Tell us how that came about and how you developed that specialty.
I believe I actually became interested first because of some children that were in the ICU when I was a resident who had bad injuries. And when I did my, in medical school, I got ahead of myself. In medical school, I did a rotation with the county medical examiner who ran the morgue in the city of St. Louis. And because I was interested in pediatrics, She had me review all of the pediatric deaths from abuse that she'd seen over a period of maybe 10 years leading up to when I was there. And that got me very interested in the idea. And then as a resident, I saw additional.
She should have stayed in the morgue. The morgue would have been a great place for her where she can't hurt anybody.
Children that increased my interest. And then in my fellowship in ambulatory pediatrics, I worked with the director of the sexual abuse evaluation program at Cardinal Glennon Children's Hospital. I worked with them like once a week or close to that, seeing children in their sexual abuse evaluation program.
Did you subsequently undergo additional training in child abuse pediatrics?
So because of when I started this, which was in the late 80s, there wasn't really what's called fellowship training in child abuse pediatrics. So what I ended up learning over the years was mostly through experience. And beginning in 1988, I was the director of a sexual abuse evaluation program in New Brunswick, New Jersey at the Robert Wood Johnson University School of Medicine. And I was a teaching general pediatrician there. And then in 1990, I moved back to Florida, and I actually took a general pediatrics faculty position at All Children's Hospital. And as part of my job, I asked them if I could work with the child protection team. And so from there, I just ended up seeing virtually all the children that have come through All Children's Hospital for the last 32 years who needed evaluations for alleged child abuse and neglect. So I gained my training, if you will, in the trenches, just seeing children, looking things up, reading about it,
Looking things up on Google.
Expert colleagues, learning from the radiologists, the neurosurgeons, the other people who work with these children down at All Children's.
By the way,
and
whoever said she didn't go in front of the jury, she's talking to the jury right now. I saw one of you in chat said she didn't go in front of the jury. She did. And Jay Hatch called her. You realize this is Jay Hatch attorneys who put her on the stand. And that's one of the appeal issues they're saying. It's like, well, if she came off so bad, who put her on the stand? We didn't. You did. We showed one clip of her in her deposition, which I should have played first so you could see the difference between, well, maybe we'll play it afterwards if we have time. The difference between her deposition look and her behavior, which was so aggressive. And this is completely different. Well, maybe we'll do that.
And ended up acquiring a pretty high level of expertise.
Did there come a point in time at which you applied for board certification in child abuse pediatrics?
Yes. So in 2009 was the first year that a board certification was made available for the specialty of child abuse pediatrics. And at that time, as I mentioned, because there wasn't really a fellowship in child abuse pediatrics, which would be 2 or 3 years additional training, the people who were allowed to sit for the exam could also be people who had at least 5 years experience in evaluating children for child abuse, were working in that specialty for at least 20 hours a week, which I qualified for both of those. And also you needed to have essentially a letter sent to the American Board of Pediatrics.
I'm telling you, chat, this was not proffer. The proffer was before this. She is talking to the jury, and you can tell because she's looking at them. When she looks that way, she's looking at the jury. There was a proffer that was done, but this is not it. And you can tell the difference because during her proffer, she was more like she was in her deposition, like aggressive and stuff. This is her actual testimony in front of the jury. Trust me, I remember this.
Someone who was kind of a recognized expert in child abuse who would sort of vouch for you that you were a person that should be allowed to take the exam. So I took that exam, I believe in November of 2009. It was in the fall. And then I think early January was notified that I had passed the exam, and therefore
There's a literal monster in her face. Do you see it? Do you see the monster? I don't trust people who look like this. I'm sorry, I just don't. There's a literal monster in that face. Keep watching her facial expressions. There's a monster in there.
was board certified in child abuse pediatrics.
Now, did there come a time in your career at which you became involved with the child abuse, or excuse me, the child protection team for Pinellas County?
Yes, so I worked for All Children's. I'm going to keep.
It's this area. Wait, I need my paint. Where's my paint? Oh, it's not showing up on here for me. Hold on. Let me get my paint out. Where is it? Huh. I must be in the wrong browser. This browser's weird today. Oh, I'm in Chrome. That's why. What am I doing in Chrome? Anyway, it's this area right here. Keep your eyes on this area and you'll see what I mean.
Leaving out the Johns Hopkins because I've just been using that term for 32 years. But anyway, when I went to All Children's to join the faculty, I started working with the child protection team in Pinellas County. And the hospital basically had an arrangement where they billed the child protection team when I saw cases for them for the hours that I worked, and allowed me to have the time to do that. And so for that 12-year period when I was working for the hospital, I was on campus. And so vast majority of the children who were hospitalized where there were allegations of child abuse and neglect and a medical evaluation was requested, I did those evaluations. So I was a consulting pediatrician for the child protection
Still a
team for
yes.
12 years. In November of 2002, their medical director left, and they asked me if I would take over as the medical director. So at first I tried to work out a way to keep my job at All Children's and also do that, but it wasn't really very practical. And so I ended up resigning from All Children's at that time and became the medical director for the child protection team. So for Pinellas County, that's about a 20-hour a week. I ended up working more like 26, I believe, over time, but it's about a 20-hour per week job. And so I did that, and within a few months, I started working at this private practice where I still am.
Okay. Let me back up a little bit there and try to clarify a couple of things. You indicated you resigned from what was then just All Children's Hospital,
Right.
No Johns Hopkins,
Right.
in 2002. Is that right?
Correct.
And at that time, you became the director of the child protection team for Pinellas County, correct?
Right. The term they use for the physician is the medical director. So I was the medical director. Yes.
So what is a child protection team and who constitutes it? Who were you working for at that time?
So the child protection teams, Florida has a kind of a model program for the country. And it was set up in the late 70s. I think that All Children started.
Objection, Your Honor. This is beyond scope. Sustained. Move to strike.
Sorry?
Sustained.
Can we approach him?
Sure.
All right, sidebar. The good thing about watching this on the replay is you get to go through the sidebars quickly. You know, if we ever get the transcripts, we should do sidebars of this. I would love to know the sidebars. Oh my God.
Mr. Hunter's going to ask a different question, and the jury will just disregard that last question.
I'm going to find out if we have
I
transcripts.
want to fast forward a little bit, if we can, without a history lesson. if you
Okay.
will.
Sure.
The CPT, well, let me back up. We've talked about that you resigned from Johns Hopkins All Children's, well, from All Children's Hospital in 2002.
Right.
And have you ever worked for them or been employed by All Children since then?
No.
Have you ever been employed by Johns Hopkins All Children's Hospital
No.
or Johns Hopkins?
No.
Without going into the historical details, well, let me lay the predicate this way. When you saw Maya Kowalski in 2016, were you the medical director of the Pinellas County Child Protection Team at that time?
Yes, I was.
And you had been so since 2002 in one role or another.
Correct.
And tell the jury, if you would, what a child protection team is.
Okay.
Objection again, Young Scope.
No, she can answer that question.
So in Florida, each county is covered by a child protection team. It's a multidisciplinary team that includes a medical director, usually nurse practitioners or sometimes other physicians from the county who are supervised by that medical director, and social workers who serve as what are called case coordinators. So they communicate with all the people involved in a particular investigation or case. And they also have like a team psychologist, for example, that's contracted, a team attorney, I believe. So it's a multidisciplinary team with these members, and it provides, especially in Pinellas County, one of the biggest functions of the child protection team is to provide medical evaluations when there are allegations of child abuse and neglect. And there are certain criteria that are set up under statute in terms of which kinds of situations warrant a medical evaluation. And so we kind of follow that list, if you will, in responding to requests for evaluations. The vast majority of the time, the request is made by the Child Protective Investigation Division under the Department of Children and Families. The child protection teams are under the Department of Health in Florida. And so they work side by side, but DCF doesn't run the child protection teams. And so they request for us to help them in investigating their case by looking at the medical information and guiding them in terms of whether there's medical evidence that would support a diagnosis of child abuse and neglect, and whether a child's safety is at risk as a result of that.
Okay. So in any given situation of a child abuse investigation.
All right, this just continues like this for too long. We need to go to where Greg gets in and starts cross-examining her, because basically it's just him, kissing her ass. It's just more ass kissing about, tell us about how good you are. Tell us about all this good work you do.
Providers in a situation where.
Christian, and obviously I've been there for 12 years.
Blah, blah, blah. This is how good I am. I'm so good. I don't abuse children. I'm too good for that. Let's get to her cross-examination. Actually, are we going to ever talk about, does he ever ask her questions about Maya?
The main way I became involved was because there was a report concerning child abuse or neglect.
Objection. Scope of that. Unless I could.
This is.
Her facial expressions during this sidebar are great.
You may continue, Mr. Hunter.
Thank you, Your Honor. May it please the court.
Jim, I've been an archpriestess of Moloch for 7 years now.
In early October of 2016, did you receive a call regarding Maya Kowalski from Dr. Beatrice Tepa-Sanchez?
Yes, I did.
And at that time, when you received that call, Did you have any knowledge of Maya Kowalski or her admission to All Children's Hospital?
No, that was the first I learned of it.
Okay. And Dr. Tep Sanchez contacted you regarding concerns that she had.
Yes.
And what did you do to tell us very specifically, and not at any length, if you would, what you did in response to that phone call?
I talked to her on the phone about, she was asking me about what to do about a possible case of, I believe her terms were Munchausen syndrome by proxy. And we talked about the kinds of things that are needed to assess that diagnosis, such as medical records.
Objection as to.
What?
You can continue. Mr.
Okay. Good. Sorry.
And we also talked briefly, as I recall, about this specific case. And I tried to give general advice in terms of how pediatricians can approach.
Celestial Force wants to know, is that the attorney's voice that said he thought he buried that Dracula? Yes. What is his name again? I've forgotten. Oh, Hunter. Hunter. His last name is Hunter, but the judge's first name is Hunter. That got confusing. So yeah, Attorney Hunter, he's the one who said, I thought we buried that Dracula, about the immediate jeopardy.
Concerns for Munchausen syndrome by proxy, or what I prefer to call medical child abuse.
And were you called at that point as a member of the child protection team or as a medical staff member at Johns Hopkins All Children's Hospital, or do you know?
My understanding was I was being called as the person they all had known for 32 years to be the hospital expert in child abuse and neglect, as an active medical staff member, and another active medical staff member was seeking my assistance, advice about what to do about a case where there was concern.
Now, with a call such as that, would that be considered a consultation?
That would be my understanding of what that's what I thought it was.
Did you access the medical records from Maya Kowalski at that time?
I believe I did briefly, yes.
And did you take any further action as far as evaluating the patient herself and her medical care at that time?
No, because to do anything as a child protection team medical director, I need to be asked by the investigators to provide a medical evaluation. And at that time, to my understanding, there was no actual investigation ongoing yet. And Dr. Tep Sanchez wasn't the person under Florida law who can ask me to provide that medical evaluation. So it was a Saturday, as I recall, 1-ish in the afternoon, and we had a little discussion at that time. And then I honestly didn't think about it more, do anything more about it until Monday, when I got that referral where the child protection team was asked to provide a medical evaluation.
So between the time that you spoke with Dr. Tep Sanchez and looked at the chart briefly, and the time you were advised of an investigation on Monday morning,
As I recall, it was Monday morning, yes.
did you take any action to render diagnosis, care, or treatment to Maya Kowalski?
None whatsoever.
And so you had a brief telephone conversation, and until you were told there was an investigation, you took no other action to involve yourself in this patient's care.
Correct.
Now, once you were advised of the investigation, did you undertake well, first of all, and I want you to answer this question very narrowly.
Okay.
Were you advised of an investigation and asked to conduct a medical evaluation as the medical director of the child protection team?
Yes.
And is that the point at which you began your investigation of the case?
That's the point at which I began my medical evaluation of the case. I wasn't the investigator. Those are other people. I was providing a medical evaluation for the child protection team to assist those other people.
Okay. And in conducting that investigation, were you acting as a medical staff member of All Children's Hospital, in other words, a pediatrician in consultation, or were you acting as the medical director of the child protection team?
You know, there's a slight overlap because the privileges that I have at the hospital allow me to review their records and enter the building and examine children and things like that. So there was a slight element of my active medical staff credentialing that was in play, but primarily I was acting as the medical director of the child protection team.
Who was conducting the care of Maya Kowalski at that point?
At that point, she was in the pediatric intensive care unit at All Children's. And so the ICU physicians, the pain management team, I'm not sure if there were any other consultants that were involved at that point. Certainly all the nursing staff and the support staff and everything were the ones that were managing her care. In not just this case, but in child abuse cases, I don't really get involved with the management, day-to-day management of the children at all. My role is specifically to do this medical evaluation. And so I focus on that part and not really anything related to, you know, whether the child gets a regular diet or what medications they're on or how often they're getting vital signs or any of that kind of thing.
And is your involvement in the medical evaluation as the CPT medical director part of your, in your understanding, part of your statutory duties as the medical director of the child protection team?
Yes.
With respect to Maya Kowalski, did you ever write a consultation in her chart?
So the physicians that are treating the children that I see down there for a child abuse evaluation obviously are going to be helped if they know all the medical data related to that potential diagnosis. And so recently there's a different electronic medical record system and it doesn't exist anymore. But at the time that I was involved with this case, what I would routinely do would be to provide my medical report to the treating physicians at the hospital to assist them. And that's okay when they basically ask me if they can have my information, my report, then I can provide it to them. There was a sort of a super confidential kind of process that was set up so that not, you know, the housekeeping staff couldn't look at these medical records, but a physician who was logged in that manner could see the child protection team report and could, you know, utilize that for either that time they were in the hospital or maybe a subsequent time they were in the hospital. That doesn't really occur the last 4 or 5 years or so, but that was in place at that time.
But your report would not have been placed into this portion of the chart you're referring to until you actually rendered it, completed it, and signed it much later, correct?
Typically correct, yes.
Okay. When you are in private practice, when you're managing a patient, well, let me ask you this way. When you're managing a patient in a hospital, whether it's Bayfront or Johns Hopkins, wherever, and you call for a consultant, a specialty consultant.
Yes.
What typically happens? You get a consult report in the chart?
Right. I mean, I had many years of experience, like as an actual in-hospital person, and that's what's typical. A consult order gets written. In this case, it's different because there's no consult in the All Children's medical record.
Super confidential. Is that a descriptor you need for confidential? I mean, what's more confidential than confidential? This is a good observation, chat. Super confidential.
For our child protection team evaluation. That has to go through child protection team and child protective investigations in the state of Florida. So there's never a consult order for a child abuse evaluation from a hospital physician. What they do is they make a report, or their typically social worker that's involved with the case makes a report to the hotline. That's how it works in Florida. That's how it works at All Children's.
So during the time that Maya Kowalski was at All Children's, did you ever write an order in her charge?
No, I did not.
Did you ever write a progress note in her charge?
No.
Did you text with other doctors and
Did you
tell them
spend
what to
time
do?
talk with
Yes.
The physicians that were caring for her,
Yes.
but did you see her or round on her on a day-to-day basis?
No, I saw her one time, I believe on October 13th, 2016. And I saw her one time in early November, probably between 5 and 15 minutes each time. Those were the only times I ever saw her while she was in the hospital.
And what was the purpose of your seeing her those two times?
So part of my medical evaluation is supposed to be a physical examination. So when I saw her on October 13th, I was trying to perform a physical examination, which basically she declined. So in November, again, as part of my job as the Child Protection Team Medical Director, I'm supposed to do a physical examination, and I'm also supposed to provide photo documentation for investigators and whoever else is involved in the case. So I went that day in early November to try to take some photographs of her lower extremities in terms of trying to essentially document the absence of a problem.
And did you take any such photographs?
I did not.
Did you ever interview Mr. or Mrs.
Mel,
Kowalski?
I did get your Cash
I
App.
took
I did get it. Thank you so much. Mel sent $50 on Cash App. I was going to read it when I got to the other super chats, but I do want to let you know I did see it, and I'm paying attention to my phone in case I get those notifications, because you guys know I have a hard time. Venmo notifications are so slow. It's absolutely ridiculous. Cash Apps are better though. Cash Apps I actually get. So let me see. Did you send a message there too? Let me look. No message, but thank you very much for that. I appreciate it. Appreciate
as
you.
part of my medical evaluation, I took a fairly extensive history from Mrs. Kowalski and a much more abbreviated history from Mr. Kowalski. The meeting with Mrs. Kowalski took place on October 11th, 2016, and the relatively brief interview or history taking with Mr. Kowalski occurred on
You would
October
think
13th.
so, Celestial. Yes, you would think so.
Did you ever speak to the two of them together?
I did not.
When you spoke with Mrs. Kowalski, first of all, where was it?
SM.
So at that time, Maya was still in the pediatric.
I love it when the oldies come in and are like, they know all the old jokes. Why is the leader of the 7th floor coven on my screen right now? Well, I'll tell you. So earlier today, there was an appellate court oral arguments in the Kowalski case. You know, J Hatch is trying to get out of paying the $260 million that they owe. They were ordered to pay by a jury of their peers. Remember that? Remember when that happened? Well, what had happened was they decided they were not going to pay Maya anything, and they were appealing and appealing. And finally today, we got to watch the oral arguments, which were very short, 30 minutes. And J Hatch really, they choked. Let's just put it that way. The judges weren't buying it. They weren't buying it. The judges knew this case. They knew it very well. And they had lots of questions for J Hatch, no questions for the Kowalski attorney. And I think it went Kowalski's way. We will see. They will deliberate. So the reason why the leader of the 7th floor coven is on your screen is because I told the chat if we hit the super chat goal, which we did, we would rewatch this damning testimony that she gave, because in the appeals arguments today, J Hatch's lawyer admitted that this is what lost the case for them, that she lost the case, and the jury just hated her, and just because she had smoker's voice. He literally said this. He literally said this. She had smoker's voice, and that turned the jury off. Well, who called her to the stand? J Hatch. J Hatch did. So I imagine that the appellate court is going to be like, we're not here to fix your mistakes. We're not here to go back in time and help you not make this terrible decision. Like, you didn't have a jury expert on your team who could have told you this woman's not going to play well. Don't put her on the stand. No, she didn't lose her medical license. She's still practicing. I bet she's still the director of the Pinellas whatever. How much you want to bet? Actually, I don't know. Somebody want to look that up?
Pediatric ICU. They have a family conference room kind of thing outside of the main entrance to the pediatric ICU. And because of the investigation that was being initiated and everything, I scheduled a time where the...
Oh, that's right. She left the county and she's in private practice now. I think you're right, Rogue Mama. She did not get fired. Well, unless they had some kind of agreement that said, okay, you're done now. You can early retirement or whatever. And we won't tell anybody we fired you, or I don't know. But yeah, I think private practice. I'll never get over Smoker's voice as a defense. I know, right? Look, Your Honor, we lost this case because our star witness had Smoker's voice and, the jury hated her. And yeah, it was the Smoker's voice. That was it. Not the demon inside of her that abused a kid and drove her mother to suicide. Yeah, I'm sure it was Smoker voice, J. Hatch. I mean, basically that was their argument. They had other arguments, but that one was the worst. Will it? No. The appellate, no, they will not decide today. No. It will be a written answer, and it will probably come several months from now. Maybe 6 months, 5-6 months. The appeals process is very slow. Unless they're all in agreement and they're so pissed that they just want J. Hatch to pay the money. They might come back fast, but don't expect J. Hatch to pay the money. They will appeal again. They'll appeal to the Florida Supreme Court, guaranteed. They will keep this family doing this for the next 10 years until they exhaust all their options. And then they'll declare bankruptcy or something. I don't think the Kowalskis will ever get a dime.
The child protective investigators and the people in law enforcement that were investigating the case could join me while I took my medical history. So there, as I recall, there were about 5 of those people, 2 or 3 child protective investigators, I think 2 law enforcement people, and Mrs. Kowalski. They were all...
I mean, maybe it was the smell of brimstone wafting over the jury, though. Smoker's voice and the smell of brimstone wafting over the jury. Maybe. I missed this case. Oh my God, the jokes. Oh, the jokes were so plentiful and so good. I missed this case. Sweet baby dumpster Jesus.
All in that room already when I got there for the scheduled meeting, which I believe began at 5:45 in the evening on the 11th.
Okay. Did you identify yourself to Mrs. Kowalski?
Absolutely.
How did you identify yourself?
I always say, I'm Dr. Sally Smith. I'm a pediatrician with the child protection team. And that's what I said to her.
And the other folks who were there were either law enforcement or child protection investigators?
Yes. It's possible one of the nurses was in there, but otherwise those were the people that I recall being present.
Okay. Were you wearing a lab coat?
No.
Do you ever
Lies.
wear a lab coat at all?
Well, at All Children's, no. I do in my office now since the pandemic, but for 20 years, I never wore a lab coat.
Do you wear, when you're in a hospital, do you wear a particular identification badge?
Yes, I have to wear my...
Okay, to clarify, anybody who thinks this is the appellate court, it is not. You would not have witnesses in appellate court. They don't rule on any new facts. They just look at what happened in the trial and that's it. But yeah, we're rewatching the disastrous testimony by Sally Smith.
Johns Hopkins All Children's identification badge to come in the door and to, move around. There's all these little things you put your badge up to open doors. And I have a similar one for Bayfront.
Okay. So if you're in Bayfront, for example, you wear a Bayfront badge. If you're at All Children's, you wear an All Children's.
Correct. And when I go in between, I switch badges.
Okay. When you spoke with Mrs. Kowalski, was there any question that you had identified yourself as a member of the Child Protection Team?
Absolutely none.
And did you conduct that investigation in any way as an employee or agent of All Children's Hospital, or Johns Hopkins All Children's Hospital?
No.
Did you ever hold yourself out to Mrs. Kowalski as acting on behalf of Johns Hopkins All Children's Hospital?
No. As I said, this was a scheduled meeting. Everybody knew exactly what was happening.
Did Mrs. Kowalski know?
Absolutely.
How do you know she knew that?
Objection, speculation.
Sustained.
Are you aware of how Mrs. Kowalski might have known that this meeting was going to take place?
As I said, they were all in the room when I got there. So and I believe some of these people had already interviewed her as part of their investigation. She probably recognized some of these people. They got on their badges and their, work-related clothing and things like that. So,
Objection, again, speculation as to what the odds.
Overruled, she can say what she saw.
So, and I introduced myself. I don't quite see how it's possible that she didn't know who I was and what was happening.
How long did that meeting take place?
About an hour and a half.
And you subsequently had an opportunity to speak with Mr. Kowalski?
Yes. So,
I'll
Okay.
follow up on that. When did you talk with Mr. Kowalski?
so that was on October 13th, and I'm honestly not sure exactly what time.
Okay. And how long did that discussion or meeting last?
I would guess about 10, maybe 15 minutes.
And who was present for that meeting?
The bedside nurse, I'm pretty sure she was still in the ICU that day, and Mr. Kowalski and Maya.
Did you identify yourself to Mr. Kowalski?
Yes, I did.
And how did you identify yourself?
I said, I'm Dr. Sally Smith. I'm a pediatrician with the Child Protection Team.
And then, of course, he
And
thinks
did-
you're with
did
Johns
you at any
Hopkins.
point advise Mr.
You didn't say
Kowalski
with
that
the
you were,
state, with the county.
acting on behalf of Johns
Lies.
Hopkins All Children's Hospital?
No.
They
Were you
assumed you were.
attired in much the same way as you were when you spoke with Mrs. Kowalski?
I was wearing professional street clothes both times.
Okay. And again, no lab coat.
No, I would have had my badge on both times because I was in the building, but otherwise just professional street clothes.
Now, at the time that you spoke with both Mr. and Mrs. Kowalski, and I think I'm getting the dates right, around the 11th and the 13th of October respectively, were you aware of any efforts being made to transfer Maya to another institution?
So I would say during that week, I knew that that was being investigated by, I believe, the hospital. I can't tell you exactly what day I knew that, but I definitely knew that there was an effort being made to transfer her to an inpatient intensive rehab facility.
And were you involved in that effort at all?
No,
Were you directing that effort at all?
no,
Were you directing any of the medical care of the patient at that time?
no.
How did you know that was going on?
That's why I'm not sure exactly the time frame. I know that week there was a multidisciplinary staffing that took place with people from the Sarasota County investigators and Child Protection Team and myself. And I believe there was discussion at that meeting. I believe that meeting was on the 13th, but I'm not 100% sure. But there were multiple discussions that I had with the treating physicians at All Children's that they were trying to make that kind of thing happen.
And did you have any understanding about whether there was an effort being made to wean Maya Kowalski's medication or reduce her medication as part of that effort?
I did not really have any involvement with any of that. I believe at one point later in October, maybe right around now, October of 2016, that I, knew that was happening.
Okay. And did you, once again, did you learn of that from the physicians directing her care, or did you attempt to direct that care yourself?
I learned that from communication with the attending physician.
Okay. And do you typically follow that as part of your statutory duties as child protection team medical director? In other words, follow the course of the patient's care.
Yes. Typically when I've seen a child, and then as I'm writing my report, I kind of go back in the chart, see what's happening, put some of the quote unquote hospital course into my report, and then, reach the conclusion. This was a much more extensive, lengthy process. So at that point, at the end of October, I hadn't, done any report or anything, but I was still in communication with them related to what was happening with the child abuse part of the case.
Okay. Now, let me ask that we put up trial exhibit 2123-723 in evidence.
I am looking currently for, if it looked like I'm not paying attention, I'm looking for her deposition video
Let
that
me
was
ask you to
played,
take
and
a
I am
look at
having the
this,
hardest
Doctor.
time finding it.
It's an email from
All I can find are
Kathy
clips
Beatty.
on
Do you know
Court
who Ms. Beatty
TV.
is?
Yes, I do.
So I'm looking at my
And,
coverage.
Did you in fact make a request of Ms. Beatty to get together with the treatment team to talk about Maya's upcoming needs in December?
Sorry.
It was during the plaintiff's case.
Yes, so I believe at that time I was in communication with the dependency attorneys, and there was a need to.
You can answer that question.
There was a need to present to the judge what options he could consider and choose from in terms of what the child's needs were, what the options might be for those kinds of treatments and things. And
Let's wait for the next question, Dr. Science.
Yes, let's.
Maybe approach on that.
Okay, I'm still looking for it. It's here somewhere. I'll find it, because you have to see the difference between how she is in this testimony versus in front of the jury versus how she was in deposition.
Let me ask a kind of a bottom line question here first.
Hold on a second. Can I see the attorneys again?
Oh, they're back. Judge is not done with them.
Your Honor. Going back to this exhibit, had you asked to meet with the treatment team at this point?
No, I was making that request in my role as the medical director for the child protection team to assist with that side of the situation.
Okay. Were you a member of the treatment team?
No, and I didn't attend this meeting.
Oh, so you wound up not attending this meeting?
It wasn't for me to be there. It was for them to have the discussion.
And you wanted to know what their consensus was. Well, I mean, strike that, never mind.
Come on, Howard, move it along.
Did there come a point at which you became aware of any pictures or videos being taken of Maya?
Yes.
And tell us in general how that came about.
I'm not sure from the standpoint of the treating team at the hospital. From my standpoint, that was related to attempting to have some photo documentation as part of my evaluation and that could be available as part of the investigation.
Was it your understanding, well, did you have any understanding of whether the treatment team desired any such pictures for clinical reasons?
I believe so, but what I can speak to is what I was doing with, or my role with it. And my role was related to this attempt for some, in this case, video documentation for the purposes of the investigation.
So was there ever any point during this patient's entire hospitalization at which you were part of the treatment of the team rendering?
Thank you, chat. You found it for me.
To Maya Kowalski?
No.
And did you ever hold yourself out as such?
No.
To the parents?
No.
That's all I have for now, Your Honor.
All right, here comes the cross. This is what J. Hatch now says. Lost it for them. It was all her fault, and she shouldn't have been in front of the jury. It's like, well, why did you put her there then? And you know what's funny about this? I've spoken to Anderson multiple times about this. He did not feel good about his cross-examination of her. He felt like he got no sleep the night before, and he was like so amped up and so ready that he over-prepared, and then he felt like he dropped the ball. He thought that his cross-examination was a disaster of her, and he was not happy with how it went. And isn't it funny that this is what J. Hatch says did it? This is what killed it for them. So congratulations, Greg. You did it. Was it Beatty? I thought it was Sally Smith. Maybe he said that about Beatty. Oh, who is doing the cross? Maybe it's Nick. Who's doing the cross? Maybe I'm wrong. Maybe it was Beatty. I think you're right. I think it was Kathy Beatty. You're right.
Dr. Smith, how many times have you testified in court?
It is Greg.
Probably over 300.
God help those poor
And
people she
how often
testified
have you
against.
met with defense counsel?
Well, pretty often, because usually there's a deposition in cases where I'm testifying. Oh, this one? 0.
You did not meet with Mr. Hunter
I did not.
yesterday? Did you have phone conversations with him
I did not.
and not an email?
No,
In the week before, did you?
no.
How did you know to come here today?
Because my attorney from Suncoast Center's insurance company told me to.
Are you still doing what you were doing in 2016 to this day?
I'm a pediatrician. I resigned from the child protection team last July.
You know what I just realized? Oh my God. You guys, our coverage has had so much effect on this case, from the judge with Hare Island to even in the appeals arguments. I actually think the whole smoker's voice thing must have come from our mocking this woman's voice. And you know what's funny about it is that she doesn't even really have that deep of a voice. I exaggerated that because it's funny. But not only that, I'm listening to it now that we have the hate ecosystem in the Hales case, and we have those the chronic smoker with chronic cough who's got a really deep voice. In comparison, Sally Smith doesn't sound anything like that. So is it that the internet mocked and ridiculed this woman for just being evil, and we settled on her deeper voice? It's really not all that gravelly. But it's funny that he brought that up. That must have really bothered them that that we were using voice changers. And is this because of me? This case. Oh my God. We got the judge to comment on his Hare Island though. And that was epic.
You wear several hats, Fifth Avenue Pediatrics, private pediatric practice, right?
Yes.
And then back in 2016, you were more or less director of the Johns Hopkins Child Abuse Team, right?
They don't have a team. They had residents that came to our clinic to learn about child abuse pediatrics once or twice during their second year of training. And I was the designated director for that rotation for them. And if we had maybe 5 or so over the 20 years I was the medical director, residents who came and worked with us for a month. So I would be the person that would be supervising them for those rotations.
All right, so you're in charge of the residency and
For
so
those things.
and so you were considered at this point by Dr. Tepa Sanchez as the go-to person for Johns Hopkins insofar as the
Sustained.
Have you ever heard that you were referred to as a go-to by the doctors there?
Well, they wouldn't be saying that to me, so I'd have to say no. I don't know what they say amongst themselves.
Okay. Now you said though that you weren't a part of the treatment team. Did I understand your testimony?
I was not.
Here?
Correct.
We bring up exhibit 100.
Let me show you your text messages that prove otherwise.
Next to last paragraph, bottom sentence.
Oh, Jules is in the chat. Jules, Ethan talked to you? Ethan Shapiro spoke to you? My God. Yeah, Jules was in the courtroom today. It clearly went very well. Jules is going to be on giving her recap at 6 p.m. on, Jules, what's the name of the channel? I'm going to forget. Would you please type in the channel or type the channel name in the chat so I can advertise it for you? But 6 p.m., Jules is going to be on doing her recap of what it was like to be in the courtroom. And I will tell you what channel as soon as she types it in the chat. I will tell you when I see it.
I'm sorry. Oh, okay. I see at the very top,
The last,
barely see the discharge summary note. Okay.
All right.
Okay.
Now, you weren't and didn't have any training in psychiatry, right?
Just rotations in medical school and residency.
You were not a pediatric psychiatrist.
Certainly not.
You were not a pain specialist.
No.
You were not an anesthesiologist.
No.
You were not involved in rehabilitation medicine.
No.
But you were included nonetheless in this treatment team, were you not?
No.
Let's go to 002-0006. And let's look at the bottom paragraph, third line. I think it's the last of the second and top and the third sentence. Nope. No, above.
Oh, Dr. Sally Smith, we're all heavily involved in her care. Heavily involved. What is that? What does heavily involved mean to you, ma'am?
This is at 0006, and I'm looking for the. All right. So Dr. Sally Smith was heavily involved in her care. Is that true?
As the medical director for the child protection team in a complex medical child abuse case, yes, that's correct.
Well, you were involved in considerably more than that, were you not?
Not in any type of day-to-day treatment of the child, but certainly in a role coordinating some of the elements related to the investigation in the court case.
Well, getting Maya Kowalski off of all of her medications is not part of your job with CPT, is it?
Well, so
Is
that
it or
was,
isn't it? Yes or no?
Excuse me, Your Honor. What change the question?
As soon as she says yes or no to whether it was or was not part of her job.
Look at her eyes.
Answer the specific question. If you need to explain, you can start explaining.
Darting
I'm
around.
sorry, could you just state the question again one time?
Sure. Well, deciding what medications Maya Kowalski should be on or whether to take her off of medications is not part of your job description at child protection, is it? Or was it?
The
Is that
part
yes
about,
or no?
yes, but I have to explain.
Yes, it's part of your job to do that, to manage.
Okay, tonight at 6 p.m., Jules will be recapping her experience in the courtroom of the appellate oral arguments on Trial TV Live, and that's on YouTube at 6 p.m. So tune in for that if you want to hear her experience in court.
Maya Kowalski's medications.
May I explain?
Well, yes.
So the part that was part of the question was related to taking her off medications. In cases of medical child abuse, one of the things that is important to try to do in a controlled setting like a hospital is if a child is on medications that may not be necessary, that the treatment team would consider to wean those medications in that controlled setting.
All right, so were you part of the treatment team or not?
She can't answer the
I
question.
guess it's sort of threading the needle. I wasn't writing any orders. I didn't tell them which medications to stop or wean or anything like that. But as part of the whole evaluation of medical child abuse, there's a component of what happens when they aren't getting all these medications. And so that specific little part of it was within my role.
Exhibit 2116, please. Now, you just told them to get her off as many medications as possible. Down, number 15, next to last from the bottom. I think there's a misspelling there, but we can agree.
Yeah, I believe the legal
Is
term
that
is
a text
res.
from you? To
Yes, it is.
Paula Dees?
Yes, it is.
The Paula Dees that testified, no, you wouldn't know. Probably already, but is that as many meds? It just says mess here, but it's supposed to be meds as possible?
Yes, and her reply is the last one's going off today.
Okay. So were you or were you not advising the treatment team
Sure, looks like she was.
as part of the treatment team to take Maya Kowalski off of all of these medications?
I was assisting them from the standpoint of the medical child protection team, medical child abuse realm. And as the reply makes it clear, they were already doing it and I didn't even know they were. So certainly wasn't directing that process.
You didn't know what they were. Weren't you involved in Maya Kowalski's lab results as well?
I'm not sure what you're talking about.
Exhibit 1001-0317. On November 15th, 2016, with Dr. Pagan, as part of the child protection, the treatment team, did he consult with you about an extensive chart review and recommendations?
So again,
I'm just asking whether he did or didn't.
well, clearly, I believe I had some discussion with Dr. Carroll, who this is, she's one of the hospitalists. And so that's her note. So clearly we had some discussion about documenting that certain lab tests presumably were now normal that had been abnormal. But I didn't order the tests or anything like that.
Are you saying that where it says in a progress note in the Johns Hopkins records, which you say you have access to, right?
Yes,
It says that the treatment team leader spoke at length with Dr. Sally Smith, you, right?
yes,
That you had done an extensive chart review, right?
yes.
And you were making recommendations regarding lab tests, right?
I was from the
And-
standpoint,
And you were making observations of whether they were abnormal. Is that right?
I knew she had abnormal tests that I had seen in all these medical records that I reviewed. But I'd have to look up and see. I don't really recall if these lab tests done in mid-November had any abnormalities.
A CBC, a CMP, a UA, a lipid panel ordered. Lipid panel is to check her cholesterol level, is it not?
Right, at one time hers was 363, I believe, quite elevated at various points.
So now
Look at how it says right there that she ordered the tests. She's all, I didn't order any tests. Jules, check your Twitter DMs.
you're in charge of her cholesterol as well. Is that right?
The lab tests had certain abnormalities that, based on my record review, I suspected were related to medications and potential toxicity. And so in evaluating the medical child abuse, one of the things we're trying to assess is if harm has been done, and hopefully it's reversible. So that was the thought process, the mindset that I was approaching this discussion with Dr. Carroll.
You're not a pharmacologist, are you?
I'm not.
Also, an IG profile. What's an IG profile?
Immunoglobulin.
And an IgE? What is
So that's a specific one of the immunoglobulins. There are A, G, M, and E.
And a RAST test to check and see if she had allergies?
Correct. That was one of the things in the medical records that was said to cause some of her symptoms.
Are you an endocrinologist or an allergy expert?
I see a lot of children with endocrinological and allergy problems in my general practice, and I saw a lot of them in my role at All Children's for 12 years, but I have neither board certified specialty.
You don't have a specialty in either one of those, do you?
I just said that, right?
And you were worried about her dog dander allergy, right?
Yes.
And dog dander allergy is clearly part of Munchausen by proxy, right?
It is.
Yes.
All right, we're approaching. Let's move this ahead.
Objection.
All right. And on December 13th, 2016, and I realize you might not recognize a lot of the dates, but to put it in context, by December 13th, 2016, now Maya had been at the hospital for what, 1, 2, almost 3 months? 2 months.
October
2 months.
17th to December 13th would be a little over 2 months, right?
Right. And you were still on the team, were you not?
I was still the medical director of the child protection team.
Well, you were part of the treatment team, were you not?
I was not.
1001-0200.
How are you not part of the treating team if you're ordering tests? She was ordering tests.
Did you or did you not confer with the team regarding creating a behavior chart? Bottom last 2 sentences. Highlight, please.
So,
Did you or did you not become involved in creating a behavior chart for Maya Kowalski?
looking at this note, I think I misspoke earlier. The way that I didn't see any of these ahead of time. But the way the email was written, it was that they should meet, but it looks like I probably did actually attend that team meeting. And so it looks like these were the things that were discussed related to coming up with this list of things that would potentially help the.
Sounds like the kids are
court
home.
that was involved at the time.
You just said you hadn't seen these prior to this. Why would it be important for you to see all of these notes in the medical record prior to this, if all you're here to do is tell the truth about what you know?
Objection, Your Honor, argumentative.
Sustained.
And then you had the pain team on documenting pain weekly. Is that right?
Well, I mean, it speaks for itself. These were the things that they said we talked about. I don't have an independent recollection of this specific meeting. And certainly I've been reviewing a lot of stuff the last couple of weeks, but I did not see this nor Kathy Beatty's email ahead of time. So, I'm just going by what I'm seeing right here at the moment.
Okay, so then you were involved then in changing the room?
Yeah, I'm not really sure what that's in reference to.
Was that changing the room to the 48-hour room, the surveillance room?
No, that was back in November. So
I'm sorry, go ahead.
I was gonna say, I'm not sure what this is talking about.
Okay, so were you aware that during that 48 hours, Maya Kowalski was forced to urinate and defecate on herself because she could not get over to the commode?
Objection, argumentative.
How is that argumentative?
She can answer.
Yeah, there. Thank you, Judge.
Were you part of the decision to put the commode just out of reach of her so that she could not get to it herself and had to rely on a nurse?
Absolutely not.
Were you part of
Oh my
any
gosh, she's so
decisions
unbelievable.
to make sure that the nurses
I
moved
don't believe you,
slowly
ma'am.
so that she would be forced to have the decision of either urinating on herself or worse, or I guess calling and waiting?
No, I have no idea about that or what you're talking about.
Would that be child abuse?
I think that would be a stretch.
Argumentative.
Sustained.
All right, so, if we go back then, as you were talking about, that was in December. If we go back then into October, were you again part of the treatment team with Dr. Hart, Dr. Elliott, and Dr. Dees?
No.
1001-0429, please.
Yeah, she's not credible at all. You sit on a throne of lies.
Right above the line there, please. And
She smells like beef and cheese. I'm sure of it.
now, please take a look at it, read it if you can.
Yes, I have.
All right. And here, Dr. Dees states that she spoke to you along with Dr. Hart and Dr. Elliott. Do you see that?
Yes, I'm pretty sure this is in reference to a meeting that we had on this, I think it was that day on October 18th. One of the things that's recommended in evaluating medical child abuse is to meet with the treating physicians and discuss what their observations are and everything so that I can then convey that in my report that I wasn't just sort of like out there rogue making this diagnosis, that there were other physicians with some of these other areas of expertise that I had discussed the case with and had the opportunity to hear their expert opinions. So Dr. Hart was the rehab physician, Dr. Elliott was the anesthesiologist, and Dr. Dees looks like would have been the hospitalist that was the general pediatrician taking care of her at that time. So that was the purpose of that meeting.
Well, it says here that the purpose, the first one was continue with the current plan, right?
I don't think that's what it says. I think those are two separate things.
All right. Well, wouldn't a treatment team be the team deciding about keeping with the current plan?
Yes, and I think that's what Dr. Deese was referencing. So this is her brief note at the end of the pediatric residence note, and they will put in a few sentences, sometimes more. And so I think there are 3 separate sentences here where two separate sentences that she added to, convey what her plan was for that day as the attending physician.
All right, I was just simply asking you whether you were part here of a note in which the current plan described there was discussed.
I understand, I think, what you were asking, and I'm answering the question to the best of my ability.
Okay. You're aware that on October 8th of 2016, there was no active state investigation of the Kowalskis.
Not sure exactly when the report was made, but I think at least part of the day on the 8th, that is correct. It was either late that day or the following morning. I found out about the case the following morning. So the 9th. Yes.
So what were you doing accessing Maya Kowalski's private
Love this
confidential medical records on the 8th if you were just part of the child protection team and there was no investigation?
Nicole, are you or are you not sprouting a demon from your eyebrows? Very good question. Very good question.
I was doing so under HIPAA's what's called TPO exception to the confidentiality guidelines, which allows for
Objection, move to strike for legal conclusion as to what the statute says.
Okay, I can do that. When are you doing that?
Tomorrow, maybe?
Okay, then I'll do that tonight.
Yours is the last I haven't done.
Okay.
All right. Why isn't this fast forwarding for me?
I'm gonna let these sit in here.
What are you doing? Hand washing something?
No, my jeans got, I spilled some coffee on them.
All right. Put them in the tub.
Okay.
I think this is going to end right now.
Sustain the objection, Mr. Anderson. We can re-ask the question. We'll get to a break in just a couple minutes. Mr. Anderson, within 5 minutes. We need
Oh, they must have cut this into 2 parts. Okay, that's enough of that. You can see how disastrous this was for her. Let's go over to the, just so you can see the contrast between her on the stand delivery and her deposition delivery. Here we go. And we can watch me doing it. We can look at how many Megans are on the screen. Here we go.
In pediatric psychiatry.
No, I do not.
Would you agree with me then that you do not hold yourself out as an
Wait,
expert in pediatric
wait.
psychology?
Why do I have it so fast? Oh, it's
Would
the
you
other
agree
me.
with me
This is
then
important.
That you do not hold yourself out as an expert in pediatric neurology?
No.
If you missed that because it was going too fast, yes, sir, you're not an expert in child psychiatry. You're not an expert in child psychology, right? Nope. You're about to find out how little she knows about anything.
I mean, you're agreeing with
I
me.
do not.
Would you agree with me that none of these, none of your training has involved an in-depth analysis of the diagnosis and treatment of RSD or complex regional pain syndrome?
I agree.
Now, at the very bottom of 33, the next to last couple lines is, the purpose is to solicit the medical director's opinion first, and then the statewide medical director's opinion, only if this is not sufficient. See that?
You're asking me if it says that?
In Maya Kowalski's case, was the medical director's opinion, was that you, or was there somebody above you, a medical director, whose opinion you could seek? Now, at the very bottom of 33, the next to last couple lines is, the purpose is to solicit the medical director's opinion first, and then the statewide medical director's opinion, only if this is not sufficient. See that?
Yes, I see it.
And who's the medical director there?
That would be me.
Okay. And then the statewide medical director's opinion.
Yes.
Was that ever, in Maya Kowalski's case, did you ever seek the statewide medical director's opinion?
I did recently, but I don't recall if I did at the time of the evaluation or not.
Tell me about who that was recently or is recently and what opinion you sought.
Dr. Bruce McIntosh reviewed the file. And
Look at how bad my
didn't
camera looked back
personally
then.
Seek his response.
She doesn't need any
Let me find
supervisors.
her report here real quick. Page 8.
Yes.
All right. So
The only thing that would make this better for me, though, is not having it edited. I would like to see the entire thing, and I doubt it'll ever be released in its entirety, which is why I love watching Sean McMillan's YouTube channel. I'm going to give you guys a push to go over there at Captain All Stan's right, Law shut and, up. I'm just trying to watch. I don't want to hear you. I'm here to hear Sally. Now be quiet.
As an active medical staff member.
Back out your tongue there. You're choking on your lies there, man.
At also
See that again.
Well, as an active medical staff
for you to
member
say.
for all children.
This is the part where I start yelling at
Hospital, I have
myself.
access to the electronic medical record. So I reviewed that, many documents from that medical record in compiling my report and reviewing the case. I did not print everything, so what you received of my medical records that have Johns Hopkins All Children's headings on them would be what Dr. McIntosh received.
All right, I'm gonna go make a whiskey sour. I think that's what I'm in the mood for. And I'm now that I'm all warmed That up. answers the so I'm question. gonna go- I'm Shouldn't gonna one of leave you be with this. I'm gonna drinking? go and do that. I'll be back.
all right. So Dr. McIntosh, according
Good,
to
she'll
you,
finally shut up.
received the medical records of Dr. Kirkpatrick. Is that
Thank
right?
God. Thank God that's
Yes.
over.
Dr. Hannah.
Yes.
Is that right? Dr. Barr. Is that right?
Yes.
Dr. Wassenauer. Is that
Yes.
right? He did not receive records from Dr. Chopra. Is that right?
Not to my knowledge.
Or Dr. Cantu?
I was never able to obtain records from Dr. Cantu, so I don't have them and did not have them to provide to him.
And so you were familiar with the fact that doctors Hannah, Kirkpatrick, Barr, and Wassenauer
Look at her mean
all
mugging him.
diagnosed or concurred with a diagnosis
The horns
of
are popping
complex
out
regional
from
pain syndrome, right?
in front of from behind her eyebrows. Archie Ruckus is having a meltdown.
That appears to be correct.
Tell the jury whether you believe that every mother that fails to remember to tell a new treating physician the entire medical history is committing an act of child abuse.
No.
Tell the jury whether you believe that every mother that fails to follow the directions of the doctor or the prescription to the letter is committing an act of
Look
child
at her
abuse.
demeanor.
No.
But in this case, you believe that Beata was.
Upon review of all of the extensive medical records, review of all of the observations of the child in the hospital, review of the, let's say, unconventional treatments, including hyperbaric oxygen treatment and high-dose ketamine treatment repeatedly. It was my opinion that there was ample evidence to support a diagnosis of medical child abuse. And it appeared most likely that Mrs. Kowalski was the primary one who was resulting in, or I don't know what the term is. It's not probably instigating, but initiating or whatever the child abuse.
Look how different she is.
Perpetrating the child abuse. Let's put it that way.
Just the
I mean,
predecessor.
look at how her facial expressions, the way she's talking, which is basically like, I don't give a shit what you think. It's yeah. Well, like so much different than on the stand, right? I mean, yeah, this woman sunk their case, but they had no case. But even without her, they were going to lose this. Kathy Beatty was the worst, the absolute worst. What they did, and all those doctors, all the doctors, all the nurses, remember the saint? Remember the saint? The one who was like, I just love Jesus and little girls, but no one believed her because she was clearly lying. I mean, this case, look at her face and look how different she is based on this is the fun part about taking depositions, because you always want to take the depositions of people like this or of anybody. They forget that they're not in front of that this is going to be in front of a jury. So they will behave in depositions in ways they would never behave in front of a jury. And yet this could it'll be shown to a jury, maybe.
Issues, the stuff we've been going over the last hour. Do you think that was an act of child abuse?
There was an element combined with everything else of child abuse in the prednisone utilization and administration.
I know
to
there's
the
a
child,
part in
yes.
here
Other than
where
this
she
ca-
crosses her arms. Oh yeah, here it is.
Vocal fry.
Check this out.
Not to my knowledge. Not to my knowledge. And the complex regional pain syndrome.
Uh-oh.
Good
She's pulled out
God,
the
woman.
She pulled out the vocal fry.
But you're
Stop
not
it.
an expert in it, right?
I'm not an expert in complex regional pain syndrome.
And then he says she moves spontaneously in her wheelchair without incurring pain, right?
Yes, as was observed on other occasions.
Do you consider tachycardia to be an abnormality in
Oh,
a
this
child
pisses
this
me
age?
off.
It can reflect many, many different conditions in the child.
Well, what is tachycardia?
A fast heart rate.
Okay. In last deposition, you said that a fast heart rate would be an indication of somebody being in pain, right?
It could be.
But you put no abnormalities noted on her exam. That's not really true from the actual record, is it?
Again, you probably should ask the person who made the documentation. They may be referencing that contrary to most cases of complex regional pain syndrome, she did not have any color change of her extremities, sweating abnormality.
We saw the pictures of the color changes on her legs. There are photos of it.
Mm-hmm.
Deformity.
She knows what she's talking
about. Extremities that would provide objective evidence to support her reported diagnosis.
Like
I'll
dystonia.
show you what's been marked as exhibit.
Trying to find a date on this.
So you can see that her demeanor in the deposition was far different than how she got up on the stage. It's really interesting. Like she had the slick back hair and glasses on, no makeup, like rough demeanor, crossing her arms, just being like herself. Then she gets up on the stand to talk to the jury. Her hair is down. She's wearing makeup. She's smiling at them. I mean, no one is fooled, lady. No one is. Oh, yeah, the hands and feet of Jesus. Yes, the saint, what's her name? From the 7th floor coven. She was the hands and feet of Jesus, she said. Hands and feet of Jesus. Nonsense. Okay, I'm going to be done with this now because I have to get about my day and get ready for the live stream tonight at 8 p.m. on my channel with Tug for the What the Hails updates, because I'm sure there will be some. Because there always are. I want to get to your super chats. So let's do that. Let's do it with Sally on the screen because she's just so infuriating. I already did this one. Okay. I don't have to say that again. I did that one. Yeah, did that one. Got that. Okay. Lisa Gibbs, thanks for the 10 pounds. Super sticker. Appreciate you. Karen Lewis, thanks for the 5. Towards the washer. We also have a new Lego kit of a fox we would like to email you a photo of, but can't find an email address. Where do we send it? Well, that's easy. It's right there. And Legos are fun, aren't they? I want that fox. I've seen it and I would like to have it. Frenchie's mom, GB, thanks for the 2. Yes, get Sally. Yeah. Aries 37, thanks for the 10 for the rewatch of Sally. Mel Klomp, thanks for the 2. Appreciate you. And also thanks for the 50 in the Cash App. I have my favorites. Thanks for the 5. We need a new song, Blame Slug. I'm all for it. Sticky Widget, thanks for the 2. Sally Smith, sounds like a made-up name. It does. It does sound made up. Welsh Lady Reads, thanks for the 2. Sally Smith, just to see the binders again. Carolyn B, thanks for the 2. Sally, 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 we want Sally. Jennifer Malone, thanks for the 5. Tried a new hair product to get the pretty curls. Didn't work this morning. Yeah, that happens. Took some notes from your live video tutorial. We'll try again. The products matter. They matter a lot. My routine is a curl cream. I like Cantu curl activator. It's a cream. I put that in first, right after when it's sopping wet out of the shower. Then gel, lots of it. It depends on the day, like what kind I like to use. I think I used a Cantu gel today, which I really like. It gives me a good cast. I can't remember what it's called though. But it gives me a good cast. Like they're real stiff right now, but that's because I haven't scrunched them out because they're not all the way dry. You don't ever want to get rid of the cast when they're not dry. But once it's fully dry, then you just scrunch it and it becomes soft again. So then gel, and then on top of the gel, I usually do a mousse, but today I didn't. I just did the gel and the Cantu curling or activator. And then I use a Denman brush like this to form some curls where I want them and then scrunch. And then usually I use a diffuser. Today I did air drying, which my hair usually doesn't dry this curly air drying. So it looks pretty good today. So it's liking the products. But thanks for the 5. Appreciate that. Welsh Lady Reads, thanks for the 2 pounds. Thug Life Judge and Fingers. You know, I had to get rid of the Thug Judge in the videos because it was taking up space and I hadn't used it in so long, so I don't even have it anymore. Vice Baby, thanks for the 5. Less Heavy Hair Clip Fund. Yes, thank you. Carolyn B, thanks for the 2. Need more hair talk too. Welsh Lady Reads, thanks for the 2. Kathy saying she'd be Maya's mother. Yeah, horrible. Caroline B, thanks for the 2. Save spiritual beliefs from the hospital staff. Yeah. Oh, Mel Klomp, thanks for the 2. Welsh Lady Reads, thanks for the 2. How about holding Maya down for photos? Yeah, horrible. Welsh Lady Reads, thanks for the 2. The missing birthday presents in the Christmas dress. Yeah, this case was so bad. Amber C, thanks for the 10. I've missed being with you to advocate for Maya. Cheers to working washer. Yeah, it's not working yet. I got to figure it out. I'm going to go take care of it on Friday. I'm going to go see the used washers at the place that my sister found. Mod Princess, thanks for the 2. Rewatch The Dumpster Fire. Yep. Tracy Wilden, thanks for the 2 pounds. Welsh Lady Reads, thanks for the 2. The deposition versus the appearance on the stand. Yeah, it's a big difference between the two. Sticky Widget, thanks for the 2. Sally Smith's Breadsticks. I have my favorites. Thanks for the 99-cent super sticker. Appreciate you. Daily Dysfunction. Thanks for the Canadian 2 for the goal. Welsh Lady Reads. Thanks for the 2 for moving that commode away from the bed. Yeah, horrible. Mike Middleton. Thanks for the Canadian 279. What email address should I reach out to? This one. meganfox.writer@protonmail.com. There you go. Holy crap, where did I go? Oh, there we go. I'm back. I hit the wrong button. Caroline B, thanks for the 2. Lost for words now. What happened? Well, I think we went over all of it. I think I answered those questions. E. Poindexter, thanks for the 5. Washington State Legislature is setting the stage against parental rights. Will be common to see medical kidnappings in the future. It's common now. It is common now. And I know I heard about the parental rights thing in Washington state. Listen, that state is screwed. Don't live there. You need to get out of there. It's the only state in the entire nation that went further left in this last election. You got to get out of there. They're taking away all your rights there. You don't want to be there. Brought me Nan of 2. Thanks for the 5. I had the same washing machine issue. I found out I was overfilling it with clothes. I now put less in and it's so much better. But shouldn't I be able to fill it up to capacity? You know, you can do that at the laundromat. I got yelled at by the woman at the laundromat because she said I didn't put enough clothes in. She was like, put that all in there. What are you doing? You're going to waste your money. Just shove it all in. It all fits. She was like, do you see the space? If there's any space, you can put the clothes in. She's like, these are not like your washers at home. Well, why is that? Why are our washers at home not able to do a full load? Why? That's what she said. Wender Bender, thanks for the 5. Get thee behind me, Satan. I know you need the holy water and the rosary for this case. If you're going to rewatch this, make sure you do it with your holy water next to you. Mel Klomp, thanks for the 2. Hope you get my Cash App. And I did. Thank you very much. Rogue Mama, thanks for the 2. Is this the Head Fleas twin? Her voice isn't deep enough. Arian the Vegetarian, thanks for the 5. I've missed you and your laughter so much. I've been MIA for multiple reasons, but I'm glad to be back and enjoying your sweet soul and spirit. Well, thank you so much, Arian. I appreciate that. All right, everybody. I am going to go. Boy, you know, the Maya Kowalski days were back when I didn't have any Suno back then to make songs. Can you imagine the songs we would have made about this case? Wouldn't it have been wonderful? That would have been a lot of fun. So let me see if I can send you somewhere. Hold on one second. Let's see. Let me see if I can, if there's anywhere to send you. Who is streaming right now? Be back here though, by the way, at 8 p.m. for me and Tug. But right now there's plenty of time. Oh, and don't forget to check out Jules tonight. Mods, can you redo the, Jules is going to talk all about her in-court experience and what she witnessed at the appeals oral arguments. So put that in the chat if you can to Jules's. Here, I'll show you. Let's see. Hold on. I think I have it here somewhere in my history because I clicked on it. I thought I clicked on it. Hold on, I'll find it and I'll get it to you. Maya Kowalski. Shoot, I am having the hardest time finding this thing. Do you guys have it? Did you guys find it? It's TV Trial Live, I think. Yes, Trial TV Live. All right, there it is. And here's the link. So here, Jules, tonight at 6. Here's the link. I'm putting it in the chat for you guys. There you go. Go check that out tonight at 6. But it's too early to redirect you over there. So what I am going to do is find who's streaming now. Hold, please, while I figure this out. Also, the hold music originated during Kowalski because I got a stream. That's when I got my Stream Deck, remember? Can you hear it? Is the Stream Deck working? Because my voice changer wasn't. All right, who's live? Anybody? Let's see. Melanie Little is talking about Karen Reed. Recovery Addict is doing closing arguments in Tennessee versus Megan Boz something. I think I will send you over to Melanie Little. All right, there you go. Tell Melanie I said hello and have a wonderful rest of your day. Bye, guys.